Someone make it make sense.
I'll be a couple.
Hello, everybody, and welcome. Welcome back if you were here just not that long ago as we covered the most recent hearing. Oh my God. Well, there was a hearing. We covered Karen Reed and the hearing at the end of the day, but we are here now to talk about Kohberger, and I do plan on covering the actual hearing itself. We'll probably be doing that on Saturday, but I wanted to take a look at some of these new docs that came out that pertain to the amended non-dissemination order. Shout out to Tonka, happy to see you, my friend. And also shout out to Tanel, who brought this to my attention during the Karen Reed live stream, because I hadn't seen these yet. And we did talk about this non-dissemination order and the Dateline documentary and all that on the previous Bryan Kohberger live stream. And, my take on it was there's no way that somebody didn't violate this. So we are now going to be seeing the fallout. And this was also addressed a little bit as well in the hearing. And if you guys want, we can actually watch that particular portion. Again, I'll cover the whole hearing on probably Saturday, but we can at least, if you guys want, we can watch what he said, he being Judge Hibbler, about this particular issue. And I do also have some other things we can take a look at as well, as it pertains to the car and the cell phone and what was disseminated in the Dateline documentary. So, but first, we've got here the order regarding the hearing that happened today. So the purpose of this order is to explain the reason for the sealed hearing this morning, May 15th, 2025, held to inform the parties about the orders to maintain records that the court entered today and to determine whether a sealed hearing was needed at the end of today's open hearing to discuss jury selection questions. All right. So now we are going to take a look at the order. So it looks like from what I've seen here that, so there's two of these, right? There's one that says document and records hold order. There's another one that says document and records hold order defense. And they seem to be identical with the exception that one of them says basically is tailored towards defense counsel and the other one is for the prosecution. So I think that they are basically exactly the same, but we'll take a look at this one first here, which pertains to the state. So, all righty, here we go. Documents and records hold order, and this was filed on today, the 15th. So, all right, based on sensitive, let me zoom in a little bit more, actually, sensitive information not previously publicly circulated that was reported during a recent Dateline TV program related to this case, footnote 1, The Terrible Night on King Road, Dateline aired on May 9th there. And the defendant, Bryan Kohberger, it appears likely that someone currently or formerly associated with law enforcement or the prosecution team violated this court's non-dissemination order. Such violations not only undermine the rule of law, potentially by persons charged with upholding it, that would be the state, but also significantly impede the ability to seat an impartial jury and will likely substantially increase the cost to be borne by the taxpayers of Latah County to prosecute this case by extending the time it will take to seat a jury and potentially requiring a lengthy period of juror sequestration. Accordingly, the court finds it is imperative to attempt to see that the source of such leak is identified and held to account, and that doing so is the best deterrent to future violations. It is hereby ordered that all persons who at any time, past or present, worked directly or indirectly by employment, contract, consultation, or otherwise, for or on behalf of any law enforcement or prosecution agency engaged in the investigation or prosecution of persons for the murders that are the subject of the instant case are hereby prohibited from deleting, discarding, overriding, destroying, altering, or otherwise making unavailable any, whether electronic or material form, records, files, documents, metadata, messages, emails, text messages, direct or private messages, phone logs or logs of communications, regardless of whether made or kept on a work-owned or personal account, device, or messaging app, that in any way relate to or document the fact or substance of communications with third persons, including representatives of the media, or other persons or entities outside of law enforcement, which communications in any way relate to, refer to, or concern the investigation of Bryan Kohberger, the facts or allegations uncovered or reported to law enforcement concerning Bryan Kohberger, or the investigation into the homicides that are the subject of the current or then potential criminal prosecution of Bryan Kohberger, collectively documents or singularly a document. So key part being here, communications with third persons. So representatives of the media or people outside of law enforcement. Let me just see if there's anything different on that portion with the defense one here. No, it's exactly the same. It's exactly the same. Okay. So in other words, if information was leaked to, say, Dateline, or leaked to, say, Steve Gonsalves, right? Well, anyone from the media or persons or entities outside of law enforcement. So I think it's clear that that happened, right? All such documents or materials or records that could potentially constitute a document, even if uncertain whether such meet that criteria, shall be preserved and must be protected from deletion, alteration, or loss until further order of the court. Any feature on any device or account that is set to automatically delete or overwrite information that could be covered by this order must immediately be disabled. Shout out to Meg. Welcome, welcome. It is further ordered that within 7 days, the state shall submit to the court in camera a list of all individuals within law enforcement and prosecuting agencies, past or present, who are known to have had access to any facts related to the investigation of the defendant, including but not limited to surveillance videos of suspect vehicle 1, the AT&T records for the defendant's cell phone, and the contents of the defendant's cell phone and other electronic devices and social media accounts, including internet search history, photographs, and information associated with the defendant's Amazon account, or any information referenced in the above mentioned Dateline episode regarding this case. The state is further required to provide a copy of this order to all such individuals and document that it has done so. Failure to comply with this order may be a basis for finding contempt of court and other such civil and criminal consequences as may be appropriate. Within 7 days, the state must also provide to the court a written plan designed to address and prevent the future authorized disclosure of information related to this case and what it has done or proposes to do to identify any violations of the court's non-dissemination orders previously entered in this case and those responsible for such violations. So it does not mention timing data, but I remember hearing that in the hearing. I remember him saying that because I was like, my ears perked up. I was like, what? So let me just make sure. Yeah, let's just try advance. So it might be worth watching that portion of the hearing because I remember that was said, and I think it was in reference to this. And I remember being like, what? Yeah, so there you go. And again, the defense one seems to be exactly the same. Of course, it's just swapping out the defense counsel versus the prosecution. So did you guys have any of y'all watched the Dateline thing? What I did was I just went to the spots where you've got the vehicle footage and then the cell phone. And I actually have two little clips. The vehicle I released it. I just put it out as like a video, but the cell phone one, I didn't make that public. I have it like saved because I wanted to be able to like explain what we are looking at. And I haven't shown that on any live stream yet. So maybe we should take a look at that. And then I also have the hearing. Let's do that first. Let's pull up the part of the hearing where it talks about this exact issue. Because again, I think he mentions timing in advance. So, okay, hold on, give me just a second. Yeah, and the thing is like there's some things in there where they just like talked to certain people and and that's not going to be violating any type of order. But there's definitely, there's tons of stuff in that Dateline that 100%, there's no way around it. It's violating it. And Again, to me anyway, especially as it pertains to the vehicle and the cell phone. But he did reference, he as in Judge Hippler did reference the Amazon and whatnot. Again, I didn't watch the whole thing. I just watched, or I just went to the spots where it was cell phone and what should we call it? Car, vehicle. So I wouldn't have seen that. I'm just editing this thing since we're going to pull up law and crime. Okay. So give me just a second here. All righty. So I don't, in other words, point being, I don't know actually what was said in the documentary about Amazon, but it was referenced in the order we just read that he did mention Amazon. What did he say specifically? Actually, let me just go back to that real quick. He said, oh, hold on, let me do that better. So cell phone, right? Okay. So people one, okay, and then internet search history, photographs. So like any of those photographs, right? And then the defendant's Amazon account. So I don't know what was in that documentary relating to the Amazon or the photographs, but if you guys want to let me know in the chat. So these are the things he's concerned with. The point being, right, like this documentary, there was like tons of stuff in that documentary, right? But some of it is whatever. And it's just, it's not necessarily even related to the case and it won't come in at trial. So what he's listing here are the things that are contained in the documentary that are, pertaining to this investigation and were not supposed to be disseminated. So cell phone, shit, internet search history, photographs, surveillance videos of suspect vehicle one, and then the defendant's Amazon account stuff. So, okay, let me go back now to the hearing portion. Okay. Meg says she doesn't remember. That's okay. All right. So
once you get and revise your spreadsheets based upon what we've talked about today, I'll start about part of what I'm going to do with the time that we have between now and trial is start going through all those, looking at what your objections are, getting my preliminary thoughts together on that. And then we may have another hearing just to kind of go over some of that if it's stuff that I think I can rule on in advance for you, or if I have questions, et cetera. But I'll let you know.
Someone remind me, what's the new attorney's name? Josh something? Does anybody remember his last name? I'm sure y'all do.
All right. Anything else before I move on to jury instructions?
Not from us, Your Honor. Thank you.
As far as objections, Your Honor, the court has issued a number of decisions on motions and limine motions to dismiss.
Thank you.
Trial brief, the defendant indicates that he plans to raise those same objections again at trial.
So I'm just going to go ahead. This is supposed to be, again, the part about the gag order. So I'm just going to go ahead until it talks about that. Okay.
That there's a noted ongoing objection to it. I don't mind anticipating that and bringing that up.
I only have what was proffered. With the general, that's fine.
I did not read.
Probably today, or I think controversial. They're pretty stock. Don't concern yourself with punishment. The subset. So there's that.
Okay, jury selection.
It's better than stock instructions. Advise the jury. I think you'll probably get before too long a set of post-proof instructions. Understand now, likely instructions are going to be, for better or worse, as you know, the Supreme Court in last year, 2024, revised all their capital instructions. And so.
Okay, going forward a little bit. Okay, I think it's coming up right here.
The defense, sometime in late June or early July, would offer, and whether transcripts or not, have none. whatever is the potential.
For separate fees if I want both.
Not now. You understand technology set up for it of a tablet. And the
Why the heck does this video say Bryan Kohberger, judge, may appoint special prosecutor? But like, anyway, it's just way longer than it needed to be, apparently. Okay.
start? As I explained this morning, the more
Okay.
people talk to the media and the more things that are in the media that are not admissible, whether true or not, the more difficult it makes things. And so I'm going to have to figure that out as we get close. For now,
By the way, shout out to Twiz. Let me move these. Shout out to Twiz.
Intent is not to do that, but we will have plans in place to revert to that if we have to at any point during the trial. Do either of you want to make a record about sequestration at this point?
I would say the only record right now is that we understand what the court is saying during jury selection. If we still don't know if that could come up, the potential jurors should just be aware that it could come up prior.
It'll be part of the question.
Yeah.
The questionnaire, as well as part of the hardship determination is
Oh,
there some
please,
reason they would be
please.
unable? I get that they wouldn't like to be, but would there be unable? Do they have a sick family member they care for or whatever, where they have to be home, right? So we'll talk to them about that. Anything from you, Counsel, Mr. Thompson, about that?
Not at this point. I understand the court might entertain some things in a closed environment later today, and we do have some sensitive issues to raise at that.
Uh-huh.
That's my list of things. Did I miss anything, Giovanna, that you can think of? All right. That's my list of stuff. And I know this has been a very sort of nuts and bolts kind of lawyer discussion today, but that's generally the nature of pretrials when there aren't contested motions to discuss. And so that's my list. I'm happy to answer any questions about my preferences or how I handle things that I haven't talked about, or address anything else that you want to talk about. I know we do need to go to a closed session at some point to talk about what will be asked of the jury specifically. I need to avoid that getting out to potential jurors. So we'll do that in the closed session. But anything else in the public session we need to talk about?
I don't believe so, Your Honor. Thank you.
Your Honor, thank you.
Okay. Let me just look at my notes real quick before I dismiss the public, and we probably take a lunch break and then come back and take that up for that. What's that? You've already given it to him?
It's already at hand. Thank you. Oh, thank you, sir.
To you, I am going to be entering an order.
Okay.
In the
Here we go.
closed session this morning, I indicated to you I am going to be entering an order requiring retention of records by the state, and I'm going to write another one extending that to the defense as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor, and that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity. So I will be looking for that from you.
Okay, so then they go to lunch and then they didn't come back. So Meg is saying, I wonder what I guess Steve Gonsalves was thinking. What do you mean specifically there, Meg? And then Needs was saying, I'm wondering what the drunk turkey show and Greg Hughes are thinking too. I'm curious if you guys want to elaborate on what you mean by that. Like, that they were people that got information from law enforcement and provided it to the media. I mean, it's clear that, we've seen Steve do a lot of interviews and he's referenced some of those other things recently. Yeah, that's a good point. He had to add that part about immunity. Yeah, let's hear that part again. That was interesting. I agree with that.
And the power to question witnesses under oath, as well as the power to grant immunity. So,
Huh. Yeah.
magistrate inquiry, so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity.
Yeah, how do you guys take that? So also welcome AZ. I think what he means here is like, for example, if they are questioning witnesses and somebody is like, oh, this person, I got this information from so-and-so and, I saw them pass it along to so-and-so or whatever, that they wouldn't be penalized for tattling essentially. But curious what you guys think about that. So what they think about leaking. Okay, interesting. Yeah, I don't know. I don't know. See, I've never watched, where was it? I've never watched these channels, Drunk Turkey Show and Grey Hue, so I don't really know. I don't have any thoughts particularly on that, but, as it pertains to the non-dissemination order, of course, it wouldn't pertain to any of those people, including Steve, right? But like, if law enforcement gave some of this info to Steve and then Steve gave it to Dateline, you know what I mean? Like law enforcement's on the hook, right? Let me know if you guys want to review again the non-dissemination order. We did that on the last Kohberger live stream, but we can also take another look. And we did at the beginning of this live stream, we did read the order there. So it is interesting. And another thing we can take a look at here is I've got, I think you guys have probably all seen the video of the suspect vehicle 1, but welcome Sky Blue. Meg's wide awake. Yeah, I mean, we could, here's the other thing, like we could watch the whole hearing. But I was thinking it would be fun to have Twiz here. And I think he's asleep right now. I guess we could watch it more than once, but let's pull up. Okay, so Needs and Z's is elaborating. Those channels are the main ones who speak to Steve and who knows who else, and they are channels who leaked. Okay, thank you so much for that. Thank you. Yeah, how would they have gotten the 911 call? The reason I haven't even listened to that and the reason I haven't covered it is because as per the public, the court record, it still says when it gets to that thumb drive of the call or whatever, it says sealed. So that was not, a court approved situation as it were. So let me pull up the, wait, I need a new window, and pull up the car thing. Car video. Okay. They had the 911. Yeah, how would they? I don't know. How did they get those? That's interesting. So he had Steve Gonzalez on. Yeah. So, but again, though, where it would be, whatever was disseminated, if anything, right, would have been somebody from law enforcement or the state, had to tell Steve, right? And then I guess Steve would have relayed that to the drunk turkey person or whatever it is. Where is it? Oh, here it is. Okay. So this is what I was looking for. Okay. Open this in a new window. So we'll do the car and then we'll do the phone. Okay. Share this. So this is from the Dateline, of course. So this is what I saved this footage, and basically all it is I just cropped it to get rid of the Dateline logo, but you can also see it better. It's like essentially it makes it more like it's zoomed in, but I didn't do anything to it other than edit out them talking. And then, so it's just basically a compilation of the footage. So, okay. So 3:30. Yeah, great point here from Tonka. I just paused it. Obviously, if something factual is disseminated, otherwise this order wouldn't exist. Yeah, I mean, this footage alone, right? What do you guys think? Like, this is, we knew this existed and we hadn't seen it. So already right here, right? This was clearly disseminated. Dateline got this from somebody, has to be from law enforcement, right? From the state. So AZ saying no YouTuber or cable network is in trouble for cement. Well, beyond that, they're not a part of the amended non-dissemination order, right? The amended non-dissemination order specifically references basically everyone involved in the case, right? Law enforcement, prosecutors, attorneys, investigators, right? Things of that nature. So people in the media or the victims' families and whatnot, they're not subject to the non-dissemination order. But if information is disseminated to them by the previous said parties, attorneys, law enforcement, investigators, what have you, and then that gets disseminated, that's on the people who first, it's like when you're in kindergarten or preschool or whatever, and it's like, oh, there's a secret, and it's like, okay, I'm gonna tell you a secret, but promise not to tell. And they're like, okay. And then they know the secret, but then they go and spill it to everybody, right? You know what I mean? It's kind of like that. Like had whoever got this information not then disseminated it, it wouldn't be known that law enforcement ostensibly, or whoever it was, probably, just we wouldn't know that, right? It's only because it then got, whoever promised to keep a secret essentially didn't keep the secret, as it were, right? If they are witnesses under the non-dissemination order, I don't remember witnesses. But this is why I was thinking we probably would want to take another look. So let me just pull it up. Okay. Hang on. So prosecuting attorneys, defense attorneys, any agents of the attorneys, defense attorneys, any attorneys representing witnesses. So not witnesses, any attorneys representing witnesses, victims or victims' families. So attorneys representing those parties. Prohibited from making extrajudicial statements. Yep, there it is. So this is what they can't say, right? And then any attorneys involved in the case may make statements about these things, right? So, but the important part is, who does it apply to, right? So just one more time here. So who does it apply to? Prosecuting attorneys, defense attorneys, any agents of the prosecuting attorneys and defense attorneys, and any attorneys representing witnesses, victims, or a victim's family are prohibited. So witnesses are not under it. No. Nope. But their attorneys are. Their attorneys are. Yeah. So the wording there, the wording there is funny, right? I can see why people would think that, because the way that this is with the commas, right? What is it, the Oxford comma or what have you? So I think this is part of this clause, if you will. So the prosecuting attorneys, defense attorneys, any agents of the prosecuting attorneys and defense attorneys, and any attorneys representing witnesses, victims, or a victim's family. I think that's all in one statement here. So attorneys that represent these groups of people, witnesses, victims, or victims' families, the attorneys are prohibited from making extrajudicial statements. You see what I mean? It could have been made clearer, but I think that's what this is, given how this usually lines up with, or how we usually see these in filings with the law. That's how I think this is. It's essentially like a run-on sentence, right? But that's how it tends to be when it comes to the law. So, does that make sense? And remember, there's more than one iteration of this, right? So let's look at the other iterations, because part of it was they needed clarification because they were like, this is vague and whatever. So let me pull up. Objection. Motion to appeal, amend, and or clarify. We'll pull up that one, and then there's another amended non-dissemination order. So the one that we just read, this is the revised amended non-dissemination order. There's also the amended non-dissemination order. So this is first. So like, in other words, this one is from, where is it? This is from January 18th, 2023. The one we just read is from June 23rd, 2023. So we have the amended and then the revised amended. So the amended, so let's just see what the differences are. So this says the attorneys for any interested parties in this case, including the prosecuting attorney, defense attorney, and any attorney representing a witness, victim, or victim's family, as well as parties to the above entitled action, including but not limited to investigators, law enforcement personnel, and agents for the prosecuting attorney. So what's interesting, hold on, what's interesting here is that this actually mentions the investigators and law enforcement personnel. And then when you go to the revised amended, I would imagine that law enforcement personnel and investigators qualify as agents. So what's funny is this is I think supposed to clarify it. It seems like it's actually more vague and less specific, but that's how I would interpret this, right? Any agents of the prosecuting or defense attorneys. Okay, let's go back to the original. So this is from January. Prohibits any statement from which a reasonable person would expect to be disseminated. Like, this is way more specific. And then we have, then we have this one. This is the motion to appeal, amend, and or clarify. So what I'm interested in here is the clarify part. Comes now, counsel for the victim's family, the Gonzalez's, Shannon Gray, and moves the court for an amendment and or clarification of the amended non-dissemination order granted by the court. So then they do that. But then what you get is the one we read first, which is the revised amended non-dissemination order, which is more vague in terms of the parties, right, that it lists. Do you guys see what I mean? It's interesting. Yeah, I mean, the thing is like, clearly things were leaked from law enforcement. Like, that's what I see here, right? Like the cell stuff, the car. And again, what else did he mention? He mentioned stuff about Amazon and stuff about other things pertaining to the cell phone. All the things that were mentioned in that order, those he's basically laying out, like, you can basically look at that and be like, okay, whatever's in the Dateline documentary that is pertaining to those categories is like evidence that was disseminated, right? Essentially. So okay, so now, so here's the, so that would include this, right? In other words, it does, like what Tonka said earlier, it does in a way validate that some of this stuff is, I mean, this is legitimate, right? And that's true. It could have been leaked from someone working for the defense. That's true. That's true. That's true. By the way it vanishes and stuff like that, that was done by Dateline. I didn't do that. So there you get, hold on, let me go back. And actually we can put it on, part of the reason too why I released this video and put it out just like without doing anything to it was because I wanted people watching it to have the ability, if they wanted to slow it down, they could do that. So I'm actually going to take my own advice and slow it down here. And that's why I didn't add any sound. It's just as is, right? It's just literally as is. So there you actually get a kind of a good view of the car compared to what we've seen previously. Like that's, let me see. Let me slow it down more actually. And I'm sure people who are qualified to have done this and I would imagine, right? You see what I mean? Like, so compared to what we've seen so far, like these are some better views, I would say. You know what I mean? I mean, if you were to compare the quality of being able to see this car to like, I don't know, let's say the Lolliport videos in Chicanery, I mean, I don't know. It's like so crazy, right? In these cases, like the video footage is so not good. Although one would expect it to be better when it's coming from law enforcement versus a home camera, but. Oh, compare the two orders. So was there a difference? I scrolled through them or scanned through it and I didn't see a distinction. So I didn't read both of them, but is there something else that's different apart from the parties that are named in the two, Meg? Yeah. Is there a difference? Yeah. I didn't see a difference. I looked for a difference, but it seemed like in one, it would say defense and the other was like prosecution. And the thing is that this is not going to be a mistrial material here, right? It's just going to, like, in other words, the fallout of this as it stands here is people could get in trouble for violating the order, right? But as far as like for the trial itself, it's just, they're just going to have to do a more extensive voir dire, you know what I mean? And just question people really carefully, jurors really carefully. It's not going to be any type of mistrial or anything like that. So Needsum's saying, if you look at the front view of the car, you can see how the license plate is wrapped around the bottom of the car. And there are comparisons out there to a specific. Yeah, I've heard about the green Elantra. I don't know what the deal is with that. Welcome, Miss Mojo. Let's go back again now that we got it slowed down here. Here it comes. Yeah, let me know, Meg, if there is a difference though in the two orders, so I can pull those back up. Blinded by the lights. Whoa. For anyone who's listening, this is probably not very exciting, but we're watching the suspect vehicle 1 video on slow-mo here. This would be one of the times where watching would be better than just listening. I can't really see it that well there. Oh, there they got it blurred out. Interesting, AZ. Are you saying if you do like Google Earth or Google Maps, that tree is blurred out? I mean, I think too, the fact that like this was addressed and we didn't hear anything about the defense making a motion for a mistrial is part of the reason why I would say that I don't think it's grounds for mistrial, or they would be making that motion. You know what I mean? Especially if Ann Taylor is the one who brought it up to Judge Hippler. You know what I mean? It would have been brought up under the context of moving for a mistrial, I would think. Because, you know, as far as it pertains to them, even without knowing who leaked it or whatever, the fact that shit was leaked, if you're going to move for mistrial, that doesn't matter who leaked it, right? It's like the fact that it's out there would be the thing. So I don't know. Let me know, let me know where you can see the license plate thing better. Because I'm not able to see it that well yet, but let me know where it is in this series of clips if you want. Because I can't see the front license plate yet. Going up slowly. So let's pull up so thank you for that, Meg. Let me pull up, let's go back to those orders again. So got one. So this is, wait, that's the defense. What's this one? Okay, so this is the one for the state, right? So if we look at the second paragraph here, it says, you know, where is it? Okay, on behalf of any law enforcement or prosecution agency engaged in the investigation or prosecution of persons. So in terms of the people, right? All persons who at any time, worked for or behalf on any law enforcement or prosecution agency. Now in the defense, at the same place, it says all persons worked for or on behalf of the defendant or his defense counsel or otherwise engaged in the investigation. To me, what this is this is just the difference for each party. That's all this is to me. It doesn't say that it thinks, oh my God, look at the name spelled wrong. It doesn't say, at least in this paragraph, that he thinks it's one party or the other, right? He being Judge Hippler. It's just, in other words, these orders are the same, but they just swapped out. It's sort of like if you have a template for something, right? So for on behalf of the defendant, Bryan Kohberger, or his defense counsel, or his investigators, basically, right? Versus if it's the state, it's going to say people that work for the state, right? So then let's just see where alt-sit says. This paragraph is exactly the same on both because I checked that already. And then as far as this paragraph goes, it says, the state shall submit in camera a list of all individuals within law enforcement and prosecuting agencies, which that makes sense because that's what was already referenced in that other paragraph, right? It's the same. Law enforcement and prosecuting agencies. And then on this one, it says all individuals that have had access to any facts related to the investigation of the defendant. Again, this to me this isn't significant. This is just the wording different depending on the party. That's how this looks like to me, unless I'm missing something. Okay, I need to pause it when it's right in the deck screen. Okay. Look at the first paragraph of the state. Okay, will do. Which one is this? Which one is this? This is the defense. Okay. Thanks, Meg. Oh, right. Yeah. No, duh. I'm an idiot, right? Okay. Correct. Someone currently or formerly associated with law. Yeah. Okay. Let me read this part again. Based on the sensitive information, it appears likely that someone currently or formerly associated with law enforcement or the prosecution team. Thank you, Meg. And I read this and I just didn't even, yeah, there you go. So that's a great, thank you for making me take another look. There you go. Correct. Yep. That's it. There it is. It appears likely that someone currently or formerly associated with law enforcement or the prosecution team. Yeah, point blank, for sure. For sure. That's what he's saying. He's 100% saying that it was from, yeah, there you go. Couldn't be more clear there, huh? Okay, so now we'll go back to the video. It was right in the screen deck. Okay, we will keep that in mind. So it's on slow-mo. That's why it's slow-mo. The problem is the lights, right? Because it's just... I mean, okay, let me go forward to the next one. So there it's going to be leaving, I think, right? Yeah. Okay, let me go back again. The lights just ruin it, man. Yeah, I don't know how you get a good view of the front plate. I mean, something like that, but like to me, it's like I can't fucking see it there. You know what I mean? The pumpkin was blocking it. When the lights weren't too bright, then it's blocked by the pumpkin, I think. Yeah, I know, for real, right? I'm with you on that. Like I said, I'm not up on technology, so 100% I'm sure that there's software, or if that's even what you call it these days. Well, look at the trail of light. That's trippy. Whoa. Again, some of that business where it looks like it's blurry or whatever, that's Dateline's editing from going between the different timestamps and whatnot, which it's more clear when it's on normal speed. See right there? I wonder if that's one of the frame by frames where they did it. Hold on. Oh, crap. There's like a split second. Anyway, well, you can see it doing the disappearing act thing there. Do the windows look tinted? You know, it's really hard to say, I think, in my opinion. Let's watch it. Let's put it on let's take another look. Let's put it on a normal speed. Because I think if you go back and forth, you probably see things differently. Okay. Woo! Like if, for example, here's what I can say about the windows. If you compare it to all the other cars around on the street, right? So like the truck, and then there's like this little SUV thing, then there's like another car over here. If you look at those windows, and assuming that not all windows are tinted, right? If you compare it to those look completely pitch dark. So I wouldn't say it's any darker to me. You know what I mean? Like if anything, they look lighter, but it's because the bright lights, I think it makes the windows look, if anything, less dark than those other vehicles. Like if you compare it to the truck there or any of the other ones, you know what I mean? Yeah, I also think the chicken wire is kind of weird. I agree with that, but I do like the pumpkins. Festive. Woo! Yeah, that's that split second I was referencing where they might have been able to get that frame by frame with the front plate. It's like right before the lights come back on. It's like a split fucking second though. I mean, maybe like seems like maybe one of the better opportunities, but anywho. Okay, so now let's take a look at the cell phone one. So you guys haven't seen this yet. Where is it? Okay. Okay, so what I did here was I took this from the Dateline, and he's narrating. Well, here's what happens in the Dateline. He narrates this, but I muted him, right? I muted him, and then I added in the timestamps that he's narrating and saying the timestamps with the towers. And I think I made it slow down a little bit, but this is basically just the way that you can watch this without a copyright. This, as it, that's basically it. So, okay, so again, y'all haven't seen this yet unless you watch the Dateline, but you haven't seen this version. So 4:48 a.m. So this is what was said in the Dateline. Now, what's interesting, actually, I think I do compare it to a map here in a second. I haven't actually looked at this since I made it. Then there's 5:20. Right, I did put a map. Okay, good. I'm glad I did that. I'm just remembering now. 5:39. So there's the 3 towers. Okay. You guys might remember this from all the mapping that we've done. So here's what I did. I pointed, these are the towers with the orange arrows. Those are the towers. So what's interesting is if you look at the top right, if you guys can see my mouse, there's 1122 King. There's those 2 towers there, Moscow, right? According to what Dateline got and included, there's no pings off of those towers for the night of the homicides. There's no ping. Let me say that again. There's no pings off of those towers. Let me back it up. Check it out. This was kind of crazy to me. So we've got, now what basically happens in the documentary prior to 4:48 is it just says like at 3, like when it goes 3:54, whatever, it just references a tower near Pullman. And that one, it's the tower that is like right over here where my mouse is. I think they end up showing that here in a sec. So, but here's the thing. So at least from what was presented in the Dateline, at no time did they include from the night of the homicides any pinging off of the 2 towers that are right there at Moscow, right? So we got 4:48 is here, but this is Blaine. So it's funny. The way they have this, where the dot is through the house, it makes it look like this tower is really close, right? That's why this is why it's crazy, right? That's why I included my map, because it looks like these towers are close to the house, right? Would you guys agree? Durable. I'm just seeing what you guys are saying. So you're talking about the chicken wire. That's funny. Yeah. Durable, Meg. Okay. So, right. So they look close by. They look close to each other and then close to the house. It's kind of misleading, right? Nope. Not close at all, people. Is what I'm saying. So the 2 towers, again, like Lord of the Rings, that are close to the house are all the way up there in the top right. No pinging off of there. The first ping there is this tower by Blaine. That's where that, if you guys can see my mouse, there's that orange arrow there. Then the next ping is this tower here, right smack dab in the middle. Again, orange arrow. And then the last ping, you've got that tower up there on the top left with the orange arrow. That's the one near the apartments and whatnot. So all these towers on the map, right? These are I took an actual 5G tower and colorized it so you can see it. And these are in the actual locations of where these towers are. Now, what's interesting is when I was putting this together, guys, I was looking at this. Where is the 3 of them? Okay. And I was looking at it. And I was looking at what really matters, right, is the angles, right, of like what they're saying, the coverage, right? And like the, oh my God, why am I blanking on the word? Twiz would be, dude, I'll tell you what, the Karen Reed hearing at the end of that trial day just has made my brain, like, my brain's not functioning at normal capacity, I will say. Azimuth. Is that what I'm looking for? I think I'm looking for that. Anyway, but here's what's interesting is that what is portrayed here is not how it is when you check it, cross-referencing it with the cell tower mapping thing. Now, having said that, that can change, right? Like, so what we're seeing, if we pull that up, and actually we could do that if you guys wanted, but I feel bad doing it without Twiz. But yeah, if you look at that, you know, those can change where it shows you the coverage, right? Because it gets updated. But what's funny is it's actually the coverage area is honestly, it's the complete opposite. The only one that's accurate, even slightly, from what we have here, is this tower over here by Pullman on the far left. But the Blaine Tower and the 1 year Johnson over here, right, the 448 and the 520, those actually, according to the way the maps are now, the coverage area is like complete opposite direction. It's really crazy. It's like, I don't know. I'm like, all right, we'll see. But I just wanted to mention that. So then let's go back to the mappy dindle. Twiz chose to sleep in his own fault. That's hilarious. I'm sure it was awesome. I will totally watch it on replay. I totally will, Meg. Yeah. So cell towers confusing. You need a song. A song about what? Like cell phone tower parts, or, you know, I can make a song happen. The sectors don't change, but the coverage does change. I mean, and I can even, let me see here. Hang on. All right. So, oh my God. Stop it. I'm not a robot. I don't know. Where am I here? Where is it? Okay. I know where I am. So, for example, right here. So this is the Blaine Tower, right? So what I want you guys to take a look at, I'm going to zoom out, is how the coverage area goes. There's a little bit that goes to the left, but basically, let me zoom out way far so you guys can see that's the coverage area. If you zoom way out, see what I mean? It goes, it's like, look at how long it goes downward. See what I mean? So if you really were to say, okay, if you were to generalize it, you would put a triangle that's facing downward. So now let me compare that to what they had in the thing. So this is kind of accurate, although it's really more skewed, like from what we're seeing now with it, the coverage is really more skewed, not centered, but more off to the side, but downward. And then the Johnson one, let's see, let me go back to my thingy. Okay, so now the Johnson one is this one. I don't know how you would describe that, but let's compare that to so this has it going like up. You see what I mean? Like it's like it's bracketing it like up towards Pullman. You know what I mean? But if you look at how it is here with the coverage, welcome to anyone who's just now getting here. It's the opposite. Like it's actually going like like it's really pointing downward more. And then the Pullman one, I think, was pretty accurate in my opinion. And it was this one. So we'll zoom out. So there's the Pullman one. So that's going directly forward, basically. Well, and up. But like if you look at that, right? Versus see how that's pretty, like, you see what I mean? So I think is Cat Randall here? Hi, Cat Randall. And the thing is that as far as these maps are concerned, I've done a ton of research. I know Twiz has done research too, but I've done a ton of research trying to figure out what these color codes mean, right? For any of these that you click on. Like, and I cannot find anywhere what that means. So again, this is just showing, like, you know, all you can glean from it, right, is like the coverage area, essentially. You know, you got your address of the actual tower, you've got the bands, but, you know, cell 9, cell 10. Like, anyway, for example, like zones and sectors, there's no way to find that on here. It doesn't have a key. Like when you go to menu, this is what you get. The legend, I've clicked on that. That doesn't help. So anyway, have a great day at work, Kat. All right, so now let's see what else was there anything else that happens here? So we have the map. Oh, I think I zoom in. Okay, so let's go back to this. So there's this. And then, yeah, so I have it zooming in so you guys can just get an idea for the distance, as it were. Oh, yeah. Okay. So now, again, this is the narration. So I typed it up, right? This is what the narration says in the thing, documentary. So what it is this is the actual footage that is in the documentary. And then he's saying these words that are on the screen. So 11:30 a.m., hit a tower. So it's quotes, quote, hit a tower serving the towns of Clarkston and Lewiston. And this is the video that plays as he says this in the documentary. 11:38 a.m. hit a tower serving the towns of Clarkston and Lewiston. And I thought that was interesting because we know that Clarkston and Lewiston has come up and da-da-da. So yeah, so that's what this is. That's what we got. This was what was, as it pertains to the cell phone pings, this was what was in the documentary. That was new information. So yeah. Now, what might be interesting, again, we're going to watch the full hearing. I want to do it when Twiz is here. What might be interesting, though, is do you guys want to see what they're saying about it on YouTube? You know what I mean? When they're like, here's what came out of the hearing. Does anybody care? I know Meg is like, I'm here for it. So not that that's what you sound like. My brain is so fried from that Karen Reed. You know what I mean? It's just, that was so insane. I know I keep saying that, but I'm still just blown away by Breenan. So let me see here. That's all in the PCA though. Not the specific towers. Not the specific towers. Y'all know how much work I've done on that with the towers and stuff. That not the specific towers. What you get is you get the shitty map that isn't even correct because there's no roads. Anyway, it doesn't pinpoint which towers. It's just very generic. It's like the car is going south and then it goes to the west and it doesn't, you know what I mean? He doesn't name the towers. Okay, so let's see here. I'm sure you don't sound like that, Meg. Yeah, towers providing service to, but there's a fuck ton. Right? Hi, like there's a fuck ton. Do I still have my other thing? Right? Okay, we'll go back here. So when it says like, if he's being general on purpose or vague on purpose, right? In the PC, towers providing service to data. It's like, and again, it's like, it could be any of these for the most part. Like a lot of these have coverage that cover all these different areas and there's overlap. So it doesn't actually mean anything. That's why, Heather, did you see what I was just showing with the cell shit? Yeah, we covered the orders already. Actually, kind of twice. I would say 1.5 times we covered the orders. So yeah, I mean, and again, just bringing it back home here, right? Whatever he mentioned he being Judge Hippler in the orders means that what came up in the documentary pertaining to those categories is violating the non-dissemination order because it's information that was not known yet, right? So, again, it's like it mentions the camera footage from Suspect People 1, which we just watched. It mentions stuff pertaining to Amazon. It mentions like pictures on the cell phone, and then like the cell phone data and cell phone pings and whatnot, right? It's like four general categories is how I was thinking of it. So I'm just seeing if there's anything interesting on here that people talking about the hearing. I don't think I'm seeing it. Two truths and a lie tactic. It's possible. I was thinking the same thing also, Heather, right? I mean, the surveillance of the car, though, right? I mean, I think that, that's pretty obvious that if nothing, I mean, that was disseminated and that seems to be legit. I mean, we knew it existed. We just hadn't seen it. Yeah, as far as the cell towers, right? It's like there's two factors, right? There's like the locations of the towers and then where they provide coverage to. And you guys know I've delved into this in excruciating detail and depth and what have you. So that's why I recognized it immediately as being like new things here. So we're gonna get it with all three of them. There it is. But most noteworthy to me, I'm going to say it again one last time, most noteworthy to me was that at no point in that documentary, as it pertains to the night in question, right, of the homicides, these two towers up here in the top right near Moscow, they're all lonely. See, there's no orange arrow there. No orange arrow. No pings off of those towers. Where the orange arrows are, those are the towers that it pings, according to the documentary. What was Hippler saying about, what do you mean, Tonka, from the hearing? Like at the end of that clip we watched from the hearing? Is that what you're referencing? Or are you referencing something in one of the orders? It was overload, yeah. And we're going to cover the hearing. We're going to cover the hearing. And that's literally why I was like, I made that decision. Initially, I was going to be covering the hearing already. But then I made the switch to Karen Reed because I was like, all that shit that went down at the end of the day. And we could see fallout from that as court starts today. So that's why I but we're gonna watch that whole hearing. We could do it now if y'all want, but like I told Twiz I'd probably do it Saturday, hoping he could join in. But as Meg said, it's his fault for sleeping. Then stop doing what now? Oh, Tanel, I did. I know. And I shouted you out. I said, thank you, Tanel, for letting me know that these came out. I did cover them. Yes. At the beginning of the live stream. What are you saying? Stop doing what here, AZ? I don't know what you're mentioning. So Tonka, I assume you're saying yes, as in at the end of the, whatchamacallit, the clip from the hearing. We can go back to that. Okay. Oh my God. Okay, hang on. Ask and you shall receive, squirrel friends. Okay, so it was right at the end here. Oh, sorry, I'm an idiot. Didn't need to share it. There we go.
Violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like that I will execute likely over the lunch hour. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor. And that special prosecutor to ask for a magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity.
So the way I interpreted that, again, we touched on this a little bit earlier, but for any of you guys who are just now getting here, feel free to weigh in. The way that I interpreted that was like people that are basically ratting on other people that disseminated, if you will, right? Just for lack of a better term, like whoever told the secret when they promised to keep it secret, keep it safe, and then they didn't, you know what I mean, or whatever. It's like, yeah, I heard so-and-so told somebody else. I mean, I don't know. I don't know what else it could pertain to, but that's kind of how I see it. I'll play it one more time here, though.
Power to question witnesses under oath, as well as the power to grant immunity. So I will be looking for that from you.
So what do you guys think? What do you guys think? So yeah, but that was important. I'm glad we did go back to the orders though, because of how it does specify that the information was leaked from prosecution side. Prosecution side. So does anybody want to watch some of the hearing now, or it's totally up to you guys, or would you rather, I mean, I'm sure we'll probably watch it again on Saturday regardless, but we can do whatever you guys want. This was an impromptu live stream just because Tanel mentioned those docs, and I was like, all right, we're going to go live again. Yeah, we went back over that. Thanks to Meg for pointing that out. Where was it? Oh, hold on. That in the first paragraph here, it says here that someone currently or formerly associated with law enforcement or the prosecution team violated this court's non-dissemination order. And then in the defense's version, it says someone violated the order. Yeah. So good job, Meg. Meg says now. Okay. All right. We'll watch some of it. So let me see here. Just pull this up. Boop, 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 boop. Because I got a separate. All righty. Here we go. Okay. Okay. Playback speed. I have a lot of thoughts on this one, guys. All right. Here we go.
State v. Kohberger.
We're going to put these in the middle so we can look at Twiz's, because I usually move these up top, but we want to be able to see Twiz's beautiful face. So he got his hair did.
Defendant and counsel for both sides previously identified are present. We are in the public session now. I have my own agenda for what to cover today in the pretrial motion, and so I'm not sure what you have. I didn't receive any specific motions to cover today, other than I think the ones
He's pretty slow. I'm going to speed him up a little bit.
previously submitted by defense related to questioning of the jury.
All right.
As I indicated, I don't intend to discuss in the public forum what specific questions would be asked of potential jurors, because I think that inhibits the ability to get frank and unprepared answers from potential jurors. And so we may have to cover part of that in a session at the end of the day. I think we can talk about it generally without discussing the specifics, but if we need to go there, that's what we will do. Apart from that issue, as what I intend to do is kind of break down the trial process through stages. And as you have issues or questions about whether how to handle something or how the court handles something, that's your opportunity to ask as it relates to that phase of the case. And we'll just sort of proceed in that fashion. So starting.
This was very unique. Like it, you know, the overall tone of this was like, to me, just generally speaking, like treating them like they've literally never done court before, you know, and like also getting really like ahead of himself. Like, I think the way I was thinking of it at the time, again, bouncing back and forth between this and hearing, was like control freak. Like, I don't know, you guys have all seen it. We'll talk about it.
Starting with some general issues. I just wanted, and a lot of this is unfortunately going to sound like me simply lecturing about what I want and don't want. And that certainly is a large part of it, because if you know what I expect, I think it makes your job easier.
So this question here about the documents. So they're the beginning portion. So, okay, they started late, right? They were like 20 minutes or 25 minutes late. And I was texting with Twiz and he was in the hallway. And that was the part of the hearing that was sealed. Let me just pull this thing up real quick here. I keep pulling things up. So here's the deal. So what happened was, the reason they were late is because in the morning they did this. In the morning, for the first, whatever, 20 minutes, or maybe they got there earlier. Can we zoom in? Okay. They did this. So the purpose of this order is to explain the reason for the sealed hearing this morning, to inform the parties, held to inform the parties about the orders to maintain records that the court entered today, and to determine whether a sealed hearing was needed at the end of today's open hearing to discuss jury selection questions. So they addressed this whole thing about the non-dissemination order and the orders to maintain records. They did all that before court started and before the cameras came on. And then he said that he was getting them extra copies of the orders at the lunch break. So hopefully that makes sense. Yeah, micromanagement.
I can't recall whether Ms. Massoth has had any trials with me or not, but I know she's been in front of me a few times, but the rest of you have not. And so it's, I think, important that you get that information straight from me rather than from sources that you may get from asking around. So to start with, I'm not a fan of surprises, as you may have figured out by now.
Literally, I kept saying that today during the hearing. I was like, no alarms and no surprises. Shout out to Radiohead.
I want to know in advance, as far as possible, when there are issues that need to be addressed. That includes evidentiary issues. So if you know that you're going to object to some line of evidence, or you anticipate that there's going to be objections to a line of evidence, I don't want to wait until that is offered in the middle of trial. For a couple of reasons. One, I don't have the opportunity to look at the issue to the degree that I would want to in order to give you the best ruling that I can. And two, it doesn't give you the opportunity to make the best case for me that you can for either excluding or overruling any objection. And perhaps even more important than all of that, from my perspective, is in what is already going to be a quite lengthy trial, it just extends it. And nothing frustrates jurors more than sitting around in the juror room doing nothing while we're in here doing something. And so that helps guard against that and minimize that amount of downtime that we may have. So we'll have periods, as I will explain to you, before court each day and after court each day, where if you are anticipating issues that are coming up, that's the time to talk about that, not in the middle of the trial itself. I did receive the parties
there and comparing it to Karen Reed, right? He's going to set time aside. Now, that's what they do in like every normal trial, right? Is like they go ahead and have time, like for example, you know, the attorneys get there like 30 minutes or 45 minutes before the jury every day, right? And it's like, here's the time set aside where we can handle any issues, right? And it's like, get it out of the way, da da da. In other words, it's like when a judge is like, I want to hear your problems, give it to me. Give it to me, baby, right? You know what I mean? Like versus Judge Bev, who is the last one in the courtroom and gets on the bench last minute. And then it's like, I heard someone wanted to see me, deep sigh, like it's annoying, and then da da da, right? So, you know, she's always just trying to get off that bench and then gets annoyed when people raise issues and is like saying shit in front of the jury, like as if they're wasting her time. Anyway.
Stipulation regarding how to handle the IGG tip, if you will. I'm fine with that proposed instruction, and so that will be given.
Just the tip.
I think I'd asked you also to work on instruction related to the use of the terms surrounding touch DNA and other variations about that in the event that I decide to correct somebody about the use of that term. As I said, with respect to the professionals in the DNA community itself, I'm not going to prohibit it in the sense that, I'm going to sustain an objection. What I would likely do is to clarify with the jury, if the parties want me to, about that being simply a convenient title and not meaning to imply an actual source of or method of the DNA being present. And so if you haven't worked on that, please do so to get me an instruction you both can live with. Otherwise, I'll end up drafting one myself, and perhaps neither of you want to live with it. So with respect to the model, I think referred to as the dollhouse by Mr. Thompson, has that been produced for the defense to inspect?
It has, Your Honor. It's actually here in this courthouse, has been for a few.
So I adore his tie. His tie is red and green, and it looks like it has reindeer on it. So actually, I kept saying that. I was using the word like. Well, I don't even remember what I was talking. Like somebody was slaying something, but like I was talking about something in reference to this, and I guess I was like he was slaying it with this tie, but like spelled like SELEIGH, like slay, right? Slaying it. But this tie, like, oh my God, it's totally like Christmas reindeer, right? Like he's like, I'm extra Santa.
Weeks, and Mr. Herwitt facilitated the defense viewing it yesterday.
Okay.
It's available for the court's inspection. Well,
Yeah, let's not be mean to each
And
other.
just for the-
Sorry, let's not say mean things to people in the chat, please.
To inspect.
It has, Your Honor. It's actually here in this courthouse, has been for a few weeks, and Mr. Herwitt facilitated the defense viewing it yesterday.
Okay.
It's available for the court's inspection. Well, if the court would like to look at it. And just for the record, to the extent that the model was characterized as a dollhouse, I think that was an inappropriate characterization. Is an inappropriate characterization. If I'm responsible for it, I assume responsibility.
Which in my memory, I think he is responsible for it. So I do at least appreciate that he does say that, right? At the very least, because I'm pretty sure I remember being surprised. I remember being like surprised when he called it a dollhouse, because I was like, wow, like really? Because that was like sort of the joke, but then he said it. And I was like, okay, I guess he doesn't find that as offensive or whatever, because then it became like everyone was just using that term even in court. But anyway, I do, at least he's owning it, right? So,
But that's simply not an appropriate way for it to be described, given what occurred there and the victims.
I think a better term is simply a model,
Yes, sir.
rough model, given that it is admittedly not to scale precisely. So, Ms. Taylor, any record about that? You had a chance to look at it?
We did. We were able to bring 2 experts in for our request yesterday, and we appreciated being accommodated while we were here. We do have a remaining question about where the model house will be stored during the course of trial.
Where are you storing it, on the 3rd floor?
Yes, sir.
Okay. So it sounds like it's stored with the evidence of all of the prosecutors down there. And so I suppose if she needs to get access, or our experts do, we can arrange for that as well.
I should have asked a better question, Your Honor. When it's brought in
Oh, I
as a
see.
demonstrative aid, I'm curious about when it's not being used by the prosecutor or the defense and a witness, where it will sit in the courtroom.
I will find some place not in the courtroom, because I don't want it in the courtroom and it's not being used, but nearby in the event that a witness does wish to use it.
Yes, sir.
I don't see anybody bullying in the chat. So I don't know. I'm not sure. I don't see anybody bullying. Meow. I wouldn't tolerate that. We're all squirrel friends here.
The other thing that I would point out, as it sounds like you've been at least to some degree working together, and I appreciate that. As you come to stipulations on agreement on things, it's important that those be reduced to writing for your own protection. Because too often what I see is in the middle of, for example, trial,
This is actually a good idea. I have to say, this is a good idea. We've seen this before in other cases where there's like a stipulation verbally and then the issues arise. So I do think this is worth mentioning, that if they're going to stipulate things as far as the trial goes, go ahead and get that in writing.
the other side said that they were going to stipulate to that, and then they're not. That leaves me in a difficult position, because I wasn't part of those discussions, right? And so for your own protection, I think it's just important that you get those reduced to writing as much as possible.
Contract.
I did receive the parties' spreadsheets on the exhibits, which we'll go into a little more when we get to the exhibits portion of today's menu. But I appreciate getting that. There's some questions I had about it generally, and then some more homework to do on it. In terms of the witnesses, I had asked, and I think my law clerk reached out to make sure that we get a description of those witnesses, kind of like if they're, who they work for or where they're from, something that will allow me to categorize those on a juror questionnaire so that they don't just get a list of, 300 names, but can say, all right, these are witnesses, these people live in Pennsylvania. These are witnesses that work for the FBI, right? And so that they can put in context those names, which will be result in a more accurate review by them of those names to see if they know anybody. I'm not sure if that's been accomplished yet or not. And so if you haven't done that, please get that to us as soon as possible so we can incorporate those. I think the state had, and last I heard, but it's been several days, the defense had, we were still waiting for someone from the defense.
And I believe that that's been provided. My hope is that it was sufficient because I think it came back and we re-provided it.
Okay, I'll check.
If it's not sufficient, let us know.
I'll check on a break to see where it's at. All right. So I did, as I indicated this morning, receive the defense's proffer regarding alternate perpetrators. That will be sealed per request, I'm assuming per stipulation. And I want some additional information. There, what I'd like is by the 23rd, if possible, for the defense to do two things. One, provide me with whatever actual evidence you have that supports those allegations, rather than just allegations. And two, provide for me how it is you believe that what you are offering is admissible. Because it seemed to me much of what you had put in there was fairly, potentially fairly objectionable in terms of admissibility. So I would like to see that. And then I would have the state respond.
Okay, so that's about the alternate perpetrator. By the way, did you guys notice that Twiz is sitting directly behind Lauren Matthias? I texted him and I was like, did you know you're sitting behind Lauren Matthias? And he's like, who? Classic Twiz, am I right?
And I want some additional information. There, what I'd like is by the 23rd, if possible, for the defense to do two things. One, provide me with whatever actual evidence you have that supports those allegations.
He had a good one the other day. What was it? I was like, might have been his best one yet. I can't remember. Anyway, I mean, I'll probably think of it when I'm not trying to think of it, where it was like, who is somebody or what is somebody? And I was like, what? Love it.
Provide me with whatever actual evidence you have that supports those allegations, rather than just allegations. And two, provide for me how it is you believe that what you are offering is admissible. Because it seemed to me much of what you had put in there was fairly, potentially fairly objectionable in terms of admissibility. So I would like to see that. And then I would have the state respond by the 6th, which is 2 weeks. And then I would propose a hearing on the 18th.
Heather, I know who's George. Who is George?
Your Honor, on June 18th, Ms. Massad has a conflict in the morning, but we could do an afternoon hearing on that day.
The 18th. Oh, right. So they set up another hearing, right?
Can we do the 20th? The 19th is a holiday and the court is closed. I'm just not sure whether it can be done in a half day or in the afternoon or not, depending upon where we're at.
He's talking about in a couple days, right?
Your Honor, for me personally, the 20th is a little bit of an issue for personal reasons. If we could avoid that date. If we can't, then I guess we can't.
Well, let's, can we start by like noon on the 18th?
Yeah, I think he's talking about
12:30 or 1. I'm in federal court.
Let's do 12.
18th. No, it can't be because then that would be, what month are they talking about?
We do the
18th, Ms. Massad has a
June.
conflict in the
Just
morning.
kidding. Don't get too excited yet. So June 18th. Okay, so they settle that. All right, good.
by like noon on the 18th.
12:30 or 1. I'm in federal court.
Let's do 12:30. Are you handling those issues?
Alternate perpetrator. I'm, yes, very involved.
Let's do 12:30 on the 18th.
Okay, Hippler, what's next?
Next, I want to go to juror questionnaire discussion. Before I do that, this was that was, as I said, sort of a catch-all category. So
Yeah.
I want to ask you if you have questions now, because I suspect it will fit into, if you do, a more specific category, and we can address it at that point. But if you have a question or concern about anything we've talked about thus far, now's your chance.
Please, Your Honor.
No, Your Honor, thank you.
All right, juror questionnaires.
Oh, I remember this. Yeah, the court feed glitched a couple times. So, happening. Do, 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 do. Aha.
I think I talked to you about both previously when you were here to visit the facilities. Certainly counsel and the defendant, though it is an administrative proceeding, have the right to be present. But when the questionnaires are administered, but I suggested to you that perhaps your time is better spent in reviewing the questionnaires than.
Yeah, it's going to be, this thing is going to be up to his discretion, right? Great point here from Janelle that how much evidence does Hippler need to prove that someone else had more opportunity and probability of doing, and I don't think they don't need to have more probability opportunity, like compared to each other or compared to Bryan Kohberger. I think they just have to, it just has to be possible. You know what I mean? That would be crazy if they had to have more, like more than the defendant, right? That would be unreasonable.
Watching people fill them out. The process will be such that as we bring groups in to fill those out, those will immediately be scanned and then provided to counsel on a shared drive. And so I guess I wanted to get your feedback on whether I suspect this is a all for
And
one
with his
or,
tie.
not proposition.
Thank you, Your Honor. My understanding is we have both agreed that there's no need for counsel from either side to be present during that stage. We'll focus on the tasks at hand.
Okay, very well. Is that the court, Ms. Taylor?
Yes, Your Honor.
All right, very well. So as I indicated, you'll be given access via shared drive. You can do two things. One, you could save those over to a copy over to a drive in which you can make edits, or you can print and make hand edits, or you can just keep track by notebook and juror number. If you want to do the printed version, you'll need to bring your own printer and supplies in order to print those off from your war rooms. The plan will be to take the universe of jurors who are summoned and then scramble them randomly and assign them what we call a scramble number, 1 through 10,000. And then we will bring them in to fill out the questionnaires beginning with 1. So that the questionnaires that you receive first will be the jurors most likely to be in the line of fire, so to speak. But, because once we have enough jurors, we'll stop.
Kind of not the best phrasing to use there, guys, I think, for him,
In the line of fire, so to speak.
Yikes. Yikes.
Because once we have enough jurors, we'll stop. So that's the plan. Anybody have any concern with that?
No, sir.
No concerns, thank you.
Technically, under the rules, you are entitled to watch the scramble process, which literally involves the jury commissioner hitting a button. I don't know if any of you want to be there for that.
So thank you.
Sounds riveting.
Waive our presence. All right, Your Honor.
Very well. I do want to stress the security and confidentiality of the juror questionnaires, as I'm sure you're aware pursuant to Criminal Rule 23. Those are extraordinarily confidential. The copies that you receive will be, we'll maintain a copy, obviously, for appellate purposes. The copies you receive will be returned. And the defendants, they're supposed to be essentially attorney's eyes only. I'm fine if you both agree to allow an investigator to see so that they can be doing, whatever online investigation they feel appropriate as you go along. Doing that, in terms of the defendant, his access has to be with attorneys present. In other words, he can't have a copy or whatever to go back with him when he's not with you.
That makes sense, but I have one question for the court. In addition to our investigators, we have 3 that are working on the case. We would request our paralegals be allowed to assist us just with the magnitude of the task. We'd like to have the assistance of our paralegals in organizing and reviewing.
And likewise, Judge, we would hope to use our administrative assistants in the process, and they are part of our staff.
Sure, and by court and bar rules, you're responsible for their conduct, and so you'll need to make sure they understand the confidentiality of those questionnaires, and it's really your ticket on the line for their behavior. So that's fine. But I do want to stress that confidentiality because it is part of what I'm giving the jurors on the instructions, is letting them know that there's a very limited number of eyes that will review this and that the public never will. So. The plan will be to try to process the first questionnaires. As I said, you'll get them each day and go through them. After 3 or 4 days, we will start to have hearings. Those will be sealed hearings because we'll be going over the questionnaires in detail, in which you folks identify the concerns you have with the questionnaire answers, specifically whether there's a motion or agreement to strike a particular juror before we ever have to bring them in based upon the questionnaire answer. Right? And the idea is to dismiss those who are unlikely to be put on the jury because of either perceived bias, knowledge of the case, or hardship. And so, I think it helps everybody if we are trying to agree to that as much as possible. It's the reason that we are summoning as many people that we are, is so that we can really cut through the chaff and get to the wheat. Any questions about the juror questionnaire process? So the next topic I have is voir dire, more specifically.
Why is he saying it like that? Voir dire, voir dire, voir dire.
Traditionally, the way, as you know, voir dire works in Idaho is the court first does its voir dire, touching on some essentially statutory kinds of bias or knowledge. And then counsel is given that opportunity. And so much of what would be the court's voir dire, I have incorporated into the questionnaire, so as to limit my role in actively questioning the jurors or potential jurors. I may follow up on some of the answers given on the questionnaires if I feel there's a need to, but otherwise the time will be yours. What I intend to do, and I'll get your input on that, is using a model very similar to the model Judge Boyce and I came up with in the Daybell case, bringing in groups of anywhere from 15 to 20 people at a time, having a general session of questioning by the attorneys, approximately 30 minutes aside of those folks, get through challenges for cause or dismissals for hardship, et cetera, of those folks. And then who's ever left over of that group then would be subject to individual questioning by the attorneys. And so the jurors that are left over will be taken to, for example, the jury room and wait in there. And then we'll bring the jurors in one at a time to answer questions from counsel. The goal is, I'm not going to stop you if you're getting important information that needs to be got to. But the idea is after that more group discussion, the individual voir dire will be more for very sensitive topics, also for knowledge they have about the case from media or otherwise, because I don't want them to talk about it in front of other jurors. And then other topics that you sense were too sensitive to talk about in front of the others. Hopefully we can get through each of the individual jurors in 10 to 15 minutes apiece, but we'll play that by ear. We'll see.
Ask a question?
Sure.
So the 10 to 16 people in the general session, is that going to be the court's few questions and then each counsel has general questions? And just to make sure I understand, then whoever's left from there, we pull in and then we talk about case specific information, the media items?
Media items, correct.
Okay. And would you envision that during the time we talk about media items, I can also find out their views on capital punishment?
Yeah, it may be that you are able to talk about that with the larger group to a degree. There may be some who appear sensitive to that and prefer to talk about it outside, and you kind of play it by ear. So it's not a subject I'm going to forbid from being discussed in front of the larger group. And you'll have limited time with the individual. So, you need to balance how you're going to use that time.
We may have to see how it plays out, Your Honor, but in my view, talking about the views on capital punishment is fine in a bigger group. My preference would be to be able to get the media items, people that aren't going to make it, to let them go before we do that. I think it would save time to have them gone before we do the capital punishment views. If we know they're not coming, they're not going to stay because of media coverage and those kind of beliefs and views. It makes more sense to have them go before we start talking about something else. My concern is the amount of time and that the media coverage items might find their way into a discussion of capital punishment.
One thing I will say is the fact that it's going to be such a long trial, I think will hopefully deter people who have an agenda. Like they would have to really have an agenda, right? Because that's a hardship for anybody. You know what I mean?
Well, I will make it clear to the jurors that they're not to discuss anything they may have heard in the media during that general session. And we'll play it by ear. If it's not working, we can change it, right? So and this is very similar to the way Judge Boyce had done it. I think it worked well. They got a jury fairly quickly. Now, as much as the attention was in that case, obviously this one seems to have more publicity. But I think that handling it with first going through the general, because we're going to lose people based on hardship, based on, have they made up their mind? Yes, right, kind of stuff. And so we don't even need to talk to them. And then we can get into the issues, or they may, simply give a view of capital punishment in that one that it's clear that they're not qualified either one side of the coin or the other. But if you want to deal more if they're hedging or you're sensing some concerns, you can use that follow-up time in individual session to follow up on that rather than trying to do that in the public session. Any questions about that, just in terms of how the question will go? So my intent in terms of public access to the voir dire process is that during the group session, victims and defendants' family will be present. A small number of public seats will be available. And then it will be streamed to a larger room in the courthouse for anyone else in the public that wants to watch. It will not be broadcast outside of that closed circuit. Because then I lose control of the recording in the event that a juror's identity is revealed, and then I get all the internet sleuths out there trying to figure out who everybody is. And I want to protect the juror's privacy as much as possible in that regard. And so this does allow for a public access is the right, but also allows the court to tightly control that process. And then the individual voir dire will be counsel and the defendant only. And there'll be no stream.
Potential jurors' faces and names obviously won't be broadcast.
Correct. The faces will not be broadcast, and you are to only use their scramble number as their identity throughout this. So they will never, you will never speak their name, nor will I or the court. They'll only be by that scramble number, and the camera view will not show their faces.
The juror number by which we'll name them. Will that be on them, or does this court use paddles so that their numbers can be held up when we?
They'll have a laminated paper, like 8x10 paper that has cardstock laminated that has the number on it. And it'll be the scramble number, not their original reporting number. My goal is to try to get through 4 panels a day, which may not seem like it's much, but I know from the prior trial that they struggled to get 3 a day. So my goal is to try to get to 4 a day, but I want to get to at least through 3 panels a day. The plan would be is once we get through the number of jurors we need to sit, including alternates and peremptory challenges, plus a few extra in the event something changes before the time we exercise the peremptory challenges. Once we get that number, let's say that number is 50, that's where we would stop and then go to the peremptory challenges. Does that make sense? Any questions about that?
Just to clarify that I understand it, we'll get enough people that we get 50 that have not been challenged for cause and then
That has been passed for cause, correct. So once you get that, if you will, struck panel, then we will exercise the peremptories. With respect to the number of jurors, prior to Friday, I had intended to use 6 alternates, and after Friday, I intend to use 8 alternates for a total of 20. That's about the maximum that I can fit into the jury box that we intend to use. So that number, 20 plus strikes, which would be 12 strikes apiece pursuant to rule, gets us to, I think, 44. And so the plan would be to get, 50 to 55 that have passed for cause to bring back for the peremptory challenges in the event that we lose somebody for some reason in between.
So 12 strikes apiece. That's good to know.
Any questions about that process? Okay.
Sucks we can't watch it, but I guess I understand.
So, and then when we're exercising the challenges,
I
what I'm
don't
going to do
know.
is I give you
How do you
a
guys
time limit.
Oh, welcome, Scott. I mean, it's just like, I don't know. Y'all, my first trial that I watched gavel to gavel was the Derek Chauvin trial, right? George Floyd back in 2020. And that was extremely high profile. They had a really long, extensive voir dire, and that was all televised. And, they just don't show the jurors' faces. And I guess what he's saying, right, is like the internet sleuths these days, I suppose if you were to say, has it changed since 2020? Probably. I don't know. But, the internet sleuths would still be able to figure out who these jurors are based on context clues. You know what I mean? I understand needing to protect the jurors' anonymity. I get it. But I wish we could watch it because voir dire is so fucking fascinating. You know what I mean?
Geared to the number of peremptories that you have. So here, for example, you have 12 peremptories, give you each 30 minutes to exercise those. And it's a chess clock. So while the paper is with you, your clock is running. And once you hand it to the bailiff, it stops running and the other side starts running. Once you reach your 30 minutes, absent some showing of something happened outside your control, then your peremptories are over. Now, that's usually I give 1 minute per peremptory in the typical trial. I'm giving you far more than that here. It shouldn't take that much time, particularly with the number of people that you have keeping track of everything.
So now, as far as your question goes about Dylan and I guess Bethany,
if you both
that
pass
part, yes.
on a round, or let's say the defense passes at the end of round 4, and then the state passes at the beginning of round 5, that ends the use of peremptory challenges, because you both have said to me, by passing consecutively, there's nobody that you want to strike. So understand that rule as you go in. After the panel is selected, the jurors and the alternates, which the alternates won't be determined until deliberations, when by lottery, who's ever left will be determined to be the jurors, and the alternates, those who are drawn by lottery to be an alternate. But that group of jurors, and so the 20, will be taken to another location in the courthouse. I will briefly meet with them, simply to introduce to them the people that will be talking to them, which will include the trial court administrator, the jury commissioner, and Judge Cawthon, who will be acting as it relates to this case as the administrative judge during the trial, to help them understand the process that we will use for juror security, for juror privacy, for reporting, and all of that, to answer any questions they have about that process, so they know where to go to ask questions about the process, and sort of, if you will, onboarding them. Counsel won't be at that, nor will I, other than to introduce the people. And then I will leave so that I don't inadvertently hear anything that I shouldn't hear on my own. I want to stress the importance of no contact with the jurors in any way by you, your staff, your witnesses, anybody affiliated with the case. And so they need to be instructed as to that. So if you happen to see a juror somewhere else in the courthouse, or at the grocery store, or at the coffee shop.
Again, like they all know this. We all know this. It's wild to me that he's saying this. Come on, what? It's like he's like as if he may as well be saying, like, I don't know, don't come into court naked. You know what I mean? It's like, come on, dude.
You're not to even engage in pleasantries. Turn tail and run the other way as fast as you can.
No pleasantries.
If you have any contact with the juror, you need to report it immediately to myself and to opposing counsel, so we can then make any inquiry that we need to.
No
I
sound.
issued yesterday an order in this case regarding sort of the rules of the road for those attending the trial, as well as an administrative order that I imagine will be on the court's website here if it's not already, outlining some of that as it relates to outside the courtroom. So my order in this case relates to the courtroom. The order, as I signed as administrative judge, relates to the courthouse at large. Make sure you have reviewed that and make sure your team understand that. There will be portions of the building that will be off limits to the public and to you. So make sure you understand that as well. I think I told you when you were here to look at the facilities, it's important that we know where it is you intend to stay as soon as possible, as well as any witnesses you put up, et cetera, so that to the extent that we ultimately may need to sequester jurors, which once it goes to deliberation, we will have to at a minimum, that we steer you away from whatever series of hotels that we've reserved as potentially available for us to use, that you're not there. So let the staff know if you intend to stay at a hotel, if you intend to put witnesses up at a hotel, intend to have staff stay at a hotel. Let us know where that's going to be.
No, they're gonna have them stay on the streets. Great point. Thank you.
You'll each be assigned a conference room outside the courtroom,
Yeah.
and you'll be given a key to it that you may lock each day, that nobody, including janitorial staff, will have access to, where you can keep your
Great
papers
point, right?
and files if you'd like, or other materials,
Point.
and to use to meet with witnesses, et cetera, as we go along. All right, before we turn to the trial itself, any questions about the jury selection process for the jurors?
No, sir.
No questions, thank you.
So I will say, as far as the sequestration, so Ms. Mojo, are the jurors going to be able to at least order food and have the state pick up the bill? And if they are, so, okay, as far as non-sequestered, it varies by jurisdiction. In some jurisdictions, they have to pay for their own lunch. I feel like we heard in Lori Valadabel and Chad Daybell, they were responsible for buying their own lunch. I'm trying to think, but it does vary. Some places they give them a per diem for lunch. That's if they're not sequestered. So that really just does vary by the courtroom, or the jurisdiction rather. Now, if they're sequestered, that's a whole separate thing. If jurors are sequestered, they do not have to pay for their own rooms. And I believe that in most cases, if not all, if they're sequestered, they also don't pay for their food. Because they're taken completely out of their normal lives. Like if they are fully sequestered for the whole trial, like that's a lot. But at the very least, they do not have to pay for their own rooms. One thing that I always think about too, though, is how they do that. Like, do they get randomly assigned a roommate with another juror? You know what I mean? Or do they each get their own room? Like, because that could be weird. You know what I mean? And especially if you don't have an even, I don't know. I guess thinking about it, they probably have to get their own room, because what if you've got like an odd number of women versus men? You can't put a woman and a man in a room. Anyway, I guess they get their own rooms, I would imagine. But yeah, that is another consideration when he's talking about the number of hotel rooms and whatnot. Right. Yeah, that's right. Yeah, like I said, in a lot of cases, they do have to pay for their own lunch. Yep. Now in Florida, I believe they take care of your lunch for you. Sometimes you'll hear them say, we're bringing lunch in or whatever. They can order from a menu. In the Casey Anthony trial, they brought the jury in from another county, from Pinellas County. And so what they did for that, they were sequestered for the whole trial. So they put them up. But what was really, I loved how they did it there, because Judge Belvin really went above and beyond to make sure that the jury was like not just taken care of, but happy. Like, for example, when they had like a holiday weekend, he made sure that they were able to go. There was like some sports ball game that was a big deal at the time for the area, and everybody there was like, sports ball, yeah. So like he made sure that they could like watch this sports ball game, which was like a huge undertaking apparently, and that they got to have a little party afterwards and stuff like that, which was cool. They got to choose like for the restaurants they got to order from. So there was like an approved menu, and then the jurors would be like, can we also add this restaurant and that restaurant? And then they like voted and then added ones on, and then they get to order from a menu and like from these different restaurants, and they bring the food to them. And another one was they had an approved movie list, and it was really fun getting to hear the different discussions about like if they wanted, like initially it was like 3 movies on the list, and then if they wanted to add a movie, then they have to like ask for it, and then all the parties discuss it and have to decide if it's like okay to add to the list. It was really interesting, but in other words, they made sure that the jurors had as much comfort as possible. Which I appreciated. Welcome, Kane. Happy to see you. Will the hookers and blow be comped? Oh my God, Kane. But yeah, don't you guys think that's funny though? The question about the rooms, like if they pair you with a random juror and it's like you have to stay in the room with that person for like 3 months, like could be super awkward. Okay. But they love
So the trial itself, the plan is
love the great questions.
to go from Monday through Friday with
Hey,
the session with the jury beginning at 8:45 each morning and ending at 3:30.
now this is where I
Once we
lost
hit
it.
a sequestered phase, whether that be, for example, in a penalty phase or earlier in the case, should it become necessary, I will likely extend the hours of the trial to fill
Okay,
up the jurors'
Let me
day,
back this up.
45 each morning and ending at 3:30.
First of
Once we
I lost my mind when he said ending at 3:30. He's worse than Judge Bev. I mean, they're starting at 8:45, not 9, but ending at 3:30. Like, what does he go to bed at like 5 o'clock? Like, what the fuck? Now, once we hit his sequestered phase,
we hit a sequestered phase, whether that be, for example, in a penalty phase or earlier in the case, should it become necessary, I
so
will likely
that
extend the hours.
sounds like he's planning on having them be sequestered during deliberations, like in the penalty phase, if he gets convicted, right? That's what it sounds like. He didn't say if we hit a penalty phase. He said once we hit a penalty phase, as if it's, let's hear it one more time just to make sure. I mean, unless he's just not choosing his words carefully.
With the session with the jury beginning at 8:45 each morning and ending at 3:30. Once we hit a sequestered phase, whether that be, for example, in a penalty phase or earlier in the case, should it become necessary, I will likely extend the hours of the trial to fill up the jurors' days. Part of the reason to give some time at the end of the day.
Now I feel like I recall reading that somewhere, that in Idaho, if it's a capital case, like a death penalty case, that is standard procedure for them to sequester the jury during the penalty phase. I feel like maybe I did read that somewhere. like on the Idaho like administrative rules or something. But yeah, so but that's a whole, you know, that's very different, right? Than like the entire trial. So but still I would not want to be paired up with a random juror in a room. So, but 3:30.
Is so that they can do the errands of life that they need to do.
Oh, okay. Well,
But if we are hosting them, so to speak, we don't have to worry about that. And I'm sure they'd rather have their day taken up moving forward on the case. So that is the general plan. Counsel and the defendant dressed, ready to go.
I don't even
at
know what you're
8:15
talking
each
about.
morning.
Dean. What are you talking
8:15
about?
to 8:45. If there are
I
issues
was
to
there
discuss,
for
that's when we will
live
do them before trial starts.
Hold on.
As I
This is the thing I was referencing, doing things before. Kane, I was there for your live stream. I don't know what you're saying. So that before trial issues, let's see what he says here.
Counsel and the defendant dressed, ready to go at 8:15 each morning.
8:15.
From 8:15 to 8:45. If there are issues to discuss, that's when we will do them before trial starts.
Okay. So this was, I like this idea. Like I said, this is what we see in most cases. Judge Bev is such an anomaly, right? So planning in time for issues. The thing is, starting at 8:45 is funny though. Like, why not make it 9 on the dot? Like, why not make it 9 on the dot and everyone gets there at 8:30? I don't know. Whatever. It's not my courtroom, obviously. Just 8:45. It's like just you know what I mean? I don't know. Make it on the dot. Anywho, but it is all that's a good practice to have, right? Set time aside, and that way you can take up any issues. Yeah, there will always be issues, right?
First started this morning about this. This would be a really good time to discuss anything that you've just uncovered that might be an issue in the case. We will likewise have a period at the end of the day from 3:45 to 4:30-ish to similarly address issues that may be coming up.
Okay. So that's, I can't, right. So he's saying after the 3:30 mark, okay, that's fine. If you're going to let the jury go at 3:30, but you're not going to just hop off the bench like Judge Bev, it's like, okay, now we have some built-in time in case there's other issues. That's fair.
The next day or in the near future.
That's fair.
At this time, I do not intend to have trial on October 2nd and 3rd.
Okay. What's wrong with those days?
Because of a previous commitment that I have.
There we go. Never mind.
I talked to you before about potentially being gone on the 14th and 15th. As of now, I've been able to make alternate plans. So for now, you should plan on being here for trial on those days. Holidays that I could spot quickly on the calendar include September 1, October 13, and November 11. So those are
Well, I guess
holidays.
I
Unfortunately,
don't-
no court, with the exception that
I don't know what day of the week my birthday is, but if it's a weekday, I guess they'll be having court on my birthday.
if we are sequestered, we may have trial, and we'll address that as we go. Because I can't send jurors home for the holiday, and so we might as well use the time.
Mm-hmm. Yeah, to that end, also, I will say, again, just to compare it to Casey Anthony, where the jury was sequestered for the entire trial, they did court 6 days a week, Monday through Saturday, for that same purpose, to try to, get the trial done quicker. And they did full days. They did I think they did 8 to 5. And that jury was so gung-ho, they were always we'll stay late. They were totally present and we're here, we're jurying it up,
Any questions about that trial schedule? Okay. All right, in terms of special needs that you may have for trial, I'm assuming there's no need for us to have interpreters for any witnesses.
Sure.
And then technology needs, be sure that you make sure whatever technology you intend to use works in the courtroom in which we will be. The best way to do that is to contact Ms. Barrios, the trial court administrator, and reserve a time to come down and try it out. I also suggest that you use on your team somebody that is far more technologically savvy than certainly I would have been in your shoes.
Oh, boy.
Perhaps you are, but it's important to have your own IT kind of person there to deal with any issues that may come up. If you have litigation presentation software and it's not working, you might get a short recess of a few minutes to work it out. But if it's after that, we're just going to move forward and you'll have to figure out something else to use. So it would behoove you to have staff there that can deal with that. Likewise, in the event that something comes up last minute and there's a need to redact some portion of audio or video or other presentation, that you have somebody there that can do so quickly and knows how to do so quickly. And I would encourage you to plan ahead to have alternate versions of such things so that if there is a concern that's unresolved.
Okay, I'll back it up so we can get his full sentence. Welcome, Dinky. First time seeing you in the chat, my friend. Happy to see you. Welcome to the Squirrel Crew. Squirrel Crew's the best. I thought it was really funny, by the way, because Kane was playing part of your lives. I don't even know how to describe it. Kane was playing part of your live stream when we were waiting for court to start. And it was so funny because I was going back and forth between Karen Reed and the hearing. And every time I would go back to Kane, whether he was himself talking or like, I don't know, my name kept coming up. It was just really funny. I was like, what is going on? It was like ping ponging. And at one point he said he was like doing this thing where he was like Pac-Man eating you. I don't know if you watched any of it. It was highly entertaining. Highly recommend. That was really funny. Him like the antics were great. They were on point.
And I would encourage you to plan ahead to have alternate versions of such things so that if there is a concern that's unresolved going into it, you have version A and version B you can use depending upon what the outcome of that may be. Any questions about technology?
By the way, Dinky, let us know if you would like a custom command. We can show you some examples here because our regular Squirrel friends all have a custom command if they want one. If they want one, it can be whatever you want. Sky's the limit here.
In terms of what we provide, it will be a overhead, what we call the Elmo device, which is the device.
The Elmo. Okay, I'm so excited. So we love the Elmo here. Shout out to the Elmo. We have a command for Elmo as well because we love it. That's you were all sus. That's funny. There it is. We love you, Elmo. The Elmo was invented in 1927 by a Japanese fellow. And Kane was really funny when they brought the Elmo up in the hearing when I was watching it live because I don't even remember what he said about the Elmo. And Heather and I were like, facepalm, facepalm, facepalm. Anywho, yeah, the Elmo's been around since like 1927. What's really funny is you'll still see them in every trial, right? When there's the Elmo, you'll still see them struggle with it. And it's like 100 years later. Attorneys for you, right? Still struggling with the Elmo 100 years later. I love it so much.
Device where you set a piece of paper down and it projects onto the screen. And then we have a HDMI link for your computer to present whatever you want to from your computer.
They're like, what's HDMI? What's a computer? I'm still learning the Elmo.
That's our technology. So anything beyond that, you'll have to bring.
There it is, guys. By the way, I have an Elmo,
Right,
another Elmo thing.
Let's talk about seating in the courtroom, counsel table,
Hey.
and the trial broadcast.
Oh boy.
Each side, I think when we toured the courtroom, each side will have two counsel table kind of put together, which should give you, depending on how closely you want to sit together, anywhere from 4 to 5, maybe 6 seats at that table to use how you wish for yourself and your staff, and in the defense's case, the defendant. As I also indicated, I would provide a small table behind defense because they're not really as close to the bar as the state would be. A table behind you where you can have staff, 2 to 3 staff members. The state will have some room behind the bar, directly behind them for its staff. What I need from you are numbers, understanding the space that you have in the well. How many seats do you need? How many seats are you requesting and how many seats do you need are two perhaps different issues. But in terms of requesting, this does not include, for example, the victim's family or the defendant's family, but for staff. So apart from the 2 or 3 seats behind you, I'm assuming that's enough for you. For the state, likewise, 3 seats, 4 seats.
You should be able to make that work, Judge.
In terms of reserve seating for the victims, it will be for those statutory victims that was agreed to by the parties. And for the defense's family, it would be those 4 members that were identified in terms of reserve seating. What I would like to do, though, is I suspect that it's maybe that everybody won't be at trial every day. And so what I would like, excuse me, is for those that have reserved seating, in particular the victims. And I should point out, I am going to reserve 2 seats for the 2 surviving roommates who are technically victims of the burglary. I don't know whether they would have any desire to be here. I suspect not. given the way they've been treated in the media. But if they do, that they would have seats available. But anybody who has reserved seats, I'm asking that they notify the trial court administrator what their plans are for each week. So if you tell me you're not going to tell the TCA, we'd like to know, for example, we're not going to use 3 of the seats on Tuesday, so that we know, so that we can make those seats available for the lottery
What do
system.
you think you want,
It's not
Heather?
technically lottery, it's a first come system on a computerized basis.
Okay, I want to hear this. So, okay, couple things. So Dinky wants what now? Okay, also Kane is back. That's really funny. Discord is the devil's playground and Twizzle's hunting. By the way, we do have a custom emoji for Twiz for anyone who hasn't seen that yet. If you remember, check that shit out. Okay, but I also wanted to show you guys this. Let me find my Elmo thing. Here it is. Okay, so we love Nightbot here. In fact, it's DJ Nightbot, you know, just to be festive. So let me show you guys this that I made. Well, I say I made it. Really, Elmo and Nightbot made it. So let me just unshare, reshare. Okay, here we go. There we go. So every courtroom, it's great because you always get to see a different Elmo, right? And some Elmos are newfangled looking, others are outdated. So this is actually, I made this when I was covering Ezra McCandless Gavel to Gavel. So this is the courtroom from that trial in Wisconsin, okay? And this is their actual Elmo, like their actual Elmo, very outdated Elmo. So that's the Elmo. And so this is Elmo and Nightbot forever, because see, they made this. See, it's their handwriting and they drew all the hearts. And there they are, Elmo and Nightbot, DJ Nightbot, obviously. Hopefully you guys see there, he's gangster. He's ready to rap. He's got tiny hands but a big heart. So yes, I'm sure this was actually, I'm sure the very first command that I made of all the millions of commands was definitely this one right here. Are people still not clear on what the Elmo is? It's a projector, right? It's a document reader. You put the documents on and then you can zoom in and then it puts it up on a screen. Projector. It's called the Elmo. And the reason is because the dude who invented it, it's like, it stands for something, I forget what, but again, it was a Japanese dude in like 1927 and he named it that before there was ever a character named Elmo. So it's the OG. It's the OG. Okay, so let me unshare, reshare. We have lots of funny things. I'm also thinking about making another music video, like for Karen Reed, to add to the collection. That would be Rollout. And it would be clips of Higgins, like going into the room and then like carrying the bag. And like, just as an example, because it's like what you got in that bag, what you got in that room, what you got in that box, you know, all the different things. And then the other thing that would be funny is to incorporate some Kane lyric, like Kane can get involved because rats, a couple of gats, a couple of rats. Hold on. Yeah, couple of gats, couple of rats, couple of wives, couple of knives. So the rats part, right? Obviously that's Kane's territory. So anyway, I need to get on that, huh? Okay.
To know, for example, we're not going to use 3 of the seats on Tuesday, so that we know, so that we can make those seats available for the lottery system, or it's not technically lottery, it's a first come system on a computerized basis. But if we don't hear from you and you haven't made arrangements, we will assume that you don't intend to be here. So it's important that each week you let the trial court administrator know. She'll give you an email address if you contact her, where you can send an email to tell us whether you'll need all of your seats or not that week, and at which days you won't. That goes for both the victim's family and the defendant's family. Right now, the plan is, and this is subject to change, to have a reserved seating, I don't want to say reserved seat, a seat selection process by which people can go to a website each day and at a certain time, and it's kind of like buying concert tickets, indicate a desire to have a seat. And the first X number that are available that get through will have a seat. It will be necessary to bring identification to show that you are who you are.
So, okay, let me back up. So he's conflating 2 things, because here's the thing. It's not really a lottery. Hold on. Let's make sure we're clear, guys.
Right now, the plan is, and this is subject to change, to have a reserved seating, I don't want to say reserved seat, a seat selection process by which people can go to a website each day and at a certain time, and it's kind of like buying concert tickets, indicate a desire to have a seat, and the first X number that are available that get through will have a seat. It will be necessary to bring identification.
So that website will crash, whatever it is. So here's what he's saying. Here's what it sounds like to me. He's saying that the first X number that get through, right? Like buying a concert ticket. That's very different than a lottery. A lottery would be like, let's say that, X number of people, let's say they say 1,000 people, right? And they allow the first 1,000, and then from there they draw random numbers. Then you've got a lottery. But it sounds like he's saying the first X number to get through, unless he elaborates. But he says it's like a concert, right? So it's like first come, first serve, right? It's like if you can get there on Ticketmaster, back when Ticketmaster was a thing. I don't even know. Is it still a thing? Anyway. And it's like before the concert's sold out, it's like you're sitting there waiting. When is it time? And then you keep refreshing, just like Kane was doing with the hearing yesterday morning. Keep refreshing. It's like, okay. And then it's like, you want to make sure you, anyway, I just foresee though the website probably crashing.
To show that you are who you are, or are who you say you are, to get into the courtroom.
First 20
Again,
callers.
that may be subject to change. I think the intent is for Judge Cawthon to have a town hall meeting with media in June at a date to be determined later to go over sort of what that process looks like, so the media is aware, and so that then it gets publicized to the general public that would want to be here. My intent at this point is to allow a stream of the trial proceedings.
It's just what I imagine though is like whatever. Let's say at 3 o'clock. Let's just say, for example, it's like, okay, here we go, right? There's going to be like a bazillion people all sitting there doing literally the same thing and waiting for 3 o'clock. And then you know what I mean? Like I just don't know, how do you get the upper hand? Now, what I will say is if they do something like that where it does the tickets for the next day while court is in session, let's say 3 o'clock that day. Well, if you're in court, guess what you can't be doing, right? Is reserving your seat for the next day, if that's when they do it. Did he say what time? Let me back it up. Hold on. Now I'm like, wait, what's it going to be? So does he say what time? I don't know that he says a time. And I don't think he does. But yeah, if it's like during the court day and you're in the courtroom, then, you're shit out of luck, right? Unless you've got a buddy who can reserve something for you, I guess. Although, show that who you are. Although it sounds like he's going to make it so that you have to do it yourself. Do it to yourself. Again, shout out to Radiohead.
Number that are available that get through will have a seat. It will be necessary to bring identification to show that you are who you are, or are who you say you are, to get into the courtroom.
So can someone reserve a seat for you? I already have I'm already like trying to figure out how people can make this work. For people that want to be there every day, right? You have to have a dedicated buddy who will hit refresh a bazillion times and then sign up under your name. I don't know.
Again, that may be subject to change. I think the intent is for Judge Cawthon to have a town hall meeting with media in June at a date to be determined later to go over sort of what that process looks like, so the media is aware, and so that then it gets publicized to the general public that would want to be here. My intent at this point is to allow a stream of the trial proceedings.
Fuck yeah.
Controlled by the court.
Great.
To be run on the court's, where, if anybody's watching today, where it would be today, on the court's broadcast page. The views will include counsel table, the podium, the witness stand, and the bench. There'll be no production of the video, meaning there'll be no close-ups and zoom ins and zoom outs and things of that nature. It'll be static views.
Well, okay, but what about, he said Judge Cawthon? Wait, what? Judge Cawthon? Did I miss Judge Cawthon? I'm just trying to figure out how this is going to work for all the number of things. So what about though when they have the exhibits and whatnot? You know what I mean? Like if they put shit on the screen. Did I miss Judge Cawthon? Hold on.
Necessary to bring identification to show that you are who you are, or are who you say you are, to get into the courtroom. Again, that may be subject to change. I think the intent is for Judge Cawthon to have a town hall meeting with media.
You did say Judge Coffin. What the fuck? What?
You are who you are, or are who you say you are, to get into the courtroom. Again, that may be subject to change. I think the intent is for Judge Cawthon to have a town hall meeting with.
I just have to say, for anyone who's just now getting here, I hope everyone can appreciate that when Santa stands up, you can recognize that his tie is so Christmassy. It's red and green and it looks like fucking reindeer on there. Like, so I was like, Santa's tie, he be slaying it, like spelled this way. Slaying it with his tie.
Media in June at a date to be determined later to go over sort of what that process looks like so that gets, so the media is aware and so that then it gets publicized to the general public that would want to be here. My intent at this point is to allow a stream of the trial proceedings controlled by the court to be.
He's like checking his naughty list, right? Who's been naughty and who's been nice. And he's, you know, how much coal do I need for this trial? Sorry.
Run on the courts where, if anybody's watching today, where it would be today on the courts.
Wait, if anybody's watching today, aren't we all talking about how this is like a huge, like highly publicized trial? If anybody's watching today.
Broadcast page. The views will include counsel table, the podium, the witness stand, and the bench. There will be no production of the video, meaning there'll be no close-ups and zoom-ins and zoom-outs and things of that nature. It'll be static views.
He kind of paused as if he was waiting for somebody to say something and they didn't, but now I'm Taylor standing
Where
up.
the court goes further when we're talking about the reserved seating for families in the courtroom. If we have some other members of Mr. Kohberger's family that travel and want to attend the trial, can we request an extra seat for a day for them?
Yeah, we probably be able to accommodate a few days here and there, but seating is going to be very limited, right? And so I don't want to extend that beyond the
Stack people on top of people's laps. You know what I mean?
immediate family as a general rule. But if there's a specific day or two where they're going to be,
I'm just picturing somebody sitting and they've got like stacked 3 deep. You know what I mean? Like, I don't know. I'm telling you guys, that Karen Reed made me loopy.
a couple other folks in town talk to the trial court.
Haven't even had a
administrator,
cough
see what she
drop
can do.
yet.
In addition to that, we have one other person on our team that would like to have sit with the victim or with Mr. Kohberger's family. It's not somebody who would testify. So if we could have 5 seats, somebody who will
Exactly.
just assist them.
That's right.
as The media might try to talk
Stack people on top of Twiz until they hit the ceiling. You could probably fit like 12 more people in that way. Just stack them on top of Twiz.
to them
Sure.
a lot.
All right,
Heather.
I don't have a problem with that.
Heather.
I'm assuming the victim witness coordinator will want to be there as well. So
And Your Honor, as the court is aware, we have, unlike most cases, we have multiple victims here. So we will have multiple victim coordinators to work with separate families. We will coordinate that with Ms. Barrio's office to let her know.
you're
There's
talking
the
about one per
tie.
family.
Let's
Hopefully
all
not.
admire this tie, guys. There it is. Very jingle bells, very festive.
Not like that, but we're
Thank
going to need to split at least, we're going to need to have at least 2 separate groups.
All right, let's try to keep it as limited as we can, just because seats are a premium. But
Yes, understood.
Just
Your Honor, may
stack.
I also ask the
We
court
get
in regard to the
creative.
live stream from the witness stand? I believe that we've mentioned this at least in passing in our trial brief. State anticipates that we may have witnesses who, for reasons the court articulated about the other 2 victims, surviving victims, that public live stream where their images could be captured and played games with in the media world. Is it possible for the
Played games with? Like reindeer games? Sorry.
for reasons the court articulated about the other 2 victims, surviving victims, that public live stream where their images could be captured and played games with in the media
Oh my
world?
God.
Is it possible for the video of that live stream when they testify to be shut off and just have the audio? We also may have a small number of law enforcement witnesses who also do covert work, and broadcasting their images publicly would be desirable. We will advise the court. We've asked the agencies to identify anybody in that
Vicky,
capacity
have you seen the Princess Twiz pictures? I would imagine you have.
and to specify the basis, which we'll bring to the court. I just want to give Your Honor a heads up.
Yeah, I would love that.
This case is very high profile, and we've had people who have expressed reluctance to talk to us and being willing to testify for similar reasons. And I did have a chance to speak with the state this morning, and we agreed that what we'd do is take a look at our entire witness list and try to figure out people that might be more sensitive to having their video camera on their face.
Okay,
to
let's fix
testify.
that.
And we may approach the court with this stipulation for certain numbers of them.
We've done,
My
this, I tell you what, we've looked at these. They never get old. I mean, all right. And also awesome because Meg is here. So let's just write this wrong, as it were. Okay. So we're going to do Disney Princess Twiz time real quick here. We got 3 options for you guys today, courtesy of Meg P. All right. So we got Disney or Twiz Princess, I guess Disney Princess, right? Whatever. Twiz Princess. Oh, hold on. It went away. It went away. Hang on. Okay. So we've got the first one, which is, all right, let me just share this to you guys. All right, cool. So this is the one, Twiz Punzel with the little tiny boys, all the little tiny boys on the beard. There they are. So Twiz Punzel is our first Twiz as a Disney princess. So that's option number 1. Now we've got option number 2, which is Twiz's personal favorite. And this one is called Twiz, King of the Maps. Of course, all the maps are Idaho, and this is Twiz's favorite of the 3 that we have here today. Twiz, King of the Maps. Then we have, last but certainly not least, guys, we have what Twizarella, Twizerbell. We've had a number of different good names for this one. But this is Twiz looking to meet his Prince Charming at the ball with his flesh-toned dress, his gown. Now, Twiz takes issue with this one only because the length of the beard is not long enough. That's it. That's his problem. Now, as I've said before, I'm going to say it again because it never gets old to me. The twinkle in the eye, the hope that he's going to meet Prince Charming at the ball. You know what I mean? It's like, is tonight the night? Why will I meet Prince Charming? Magical, right? Isn't it just? This is why we're here. Trial and Princess Twiz. And we've done official polls on these before, and I forget. I think the first one, Twiz Punzel, I think was the winner. But also, people were saying that I may have tainted those results because I was like saying I loved the tiny boys on the beard, and then people were voting for that one. So I don't want to be impacting the results at all. That's not how we roll here. Welcome, Just Beth. Welcome, Angel. So, anywho, there we go with the flesh-colored dress. And also some nice, it almost looks like the candy type of castles in the background, like the gumdrops and whatnot. So, yeah. All right. So now we know. Now we're all up to speed. So let's go back to the trial. Bloop, bloop, bloop. Unshare or reshare as per usual. One of these days, I feel like StreamYard will make it so that you don't have to do this, and it will be amazing.
That would be with respect to victims. And I've already indicated, I think the 2 roommates are victims.
Oh, yeah, you have indicated that.
There is a compelling interest to protect them. And so just as typically when media is present, they're not permitted to photograph or video victims that may be in the courtroom. If the victim requests it, their face will not be shown during the broadcast. In terms of those that work covert, I see where the parties land on that.
Now, if you're still listening, this might be a good time to answer your question. And actually, I'm going to address this. So here's the thing. They don't have to have seats in the courtroom, and here's why. Witness exclusionary rule. He hasn't brought it up yet. He probably will. But yeah, that exists in every trial except for Murdoch because they make up their own rules in that trial. One of the many reasons I love it. But the witness exclusionary rule, right? So that would mean that they can't be in the courtroom. Now, after they testify, right, then they could be there, I guess, like in terms of the rule, right? Like if you've got the witness exclusionary rule and you've been released from your subpoena, and they're not going to recall you, then you are at that point, you can watch the trial, you can be present, you can watch it on TV, you can do all the things. But if you're a witness that's subpoenaed for the trial, right, with only a few exceptions, like for example, expert witnesses or like the defendant's family being present, if they, who knows if they'll get called, but I know you guys are all up to speed on that anyway, how they discussed that at length, had filings going back and forth, because that's an exception to the witness exclusionary rule, right? So, but as far as it pertains to the other roommates, DM and BF, they are not covered by that. So meaning that they can't, that exclusionary rule applies to them. They shouldn't be watching it. They can't be present, but now after they testify, they could. So just wanted to follow up with that.
If they weren't covert in this case, I'm not sure about that. I'll have to think about that, and you may have to convince me, because I think there is public interest at play here. And so we'll talk about it.
Thank you. Yes, sir.
And as for anyone else, you're going to have to really convince me because of the public's right. And their hesitancy can be overborne with a subpoena. And that's what subpoenas are for. So I'm probably disinclined to do that in general for other witnesses. As you can see, I'm even hesitating with people that may have a line of work that is undercover if they weren't undercover in this case. So
Right.
other folks who may be shy, probably I'm going to have to weigh heavily the public interest there.
Or I wonder if the same could be accomplished with a room where there could be a feed for certain bits of testimony to a larger group, and it's still a public open courthouse, and live streaming something that gets captured for millions of viewers that lives on for a very long time might be different. And I can work with the state and then give the court a little bit more on that, but off the top of my head, that's what I'm thinking.
What?
It's going to have to be a very compelling reason to do it. So aside from victims,
Or having them be in a different room? Okay.
while we are open in the sense that the people in the courtroom, the likelihood is we can't fit everybody in there that wants to be in there. If we start,
Now, let's remember, we don't want to lose our sense of creativity. We can always be stacking people up to the ceiling, right?
not broadcasting the testimony, the full testimony of people who would otherwise prefer not to. That's going to fill up, it's going to be a large number quickly.
Yeah.
And the best way that we have to ensure that
Stack
the
them on
public is
Twiz,
accepting of whatever verdict
stackables.
may be reached in this case is for the public to have the ability to see the evidence.
Now, one thing that's interesting, I don't know, who's this girl in the orange? She has been inching over the course of this hearing closer and closer to Twiz. She started out like in between Twiz and this other dude, and she's been getting closer and closer, and he looks like he's kind of trying to get away. Is this somebody that he knows? Do y'all know?
I'm not saying no, I'm just saying you're going to have to really convince me.
Thank you.
He's going to say you're going to butter him up like the way Cain butters his grapes. We heard about that.
All right, any questions about either the seating or broadcasting besides what we've talked about?
P. Fox, welcome on in.
All right, let's move to then opening statements.
Okay, cool. I don't think I heard this part. It must have
Let
been
me
switched here.
start with what you've probably figured out by now. I am not tolerant of argument during opening statement.
Oh, yeah.
So if somebody is arguing and there is an objection, it will be sustained. Please don't do it. What I would like you to do is,
Who is Sue?
by about the time that we're meeting
Bryan?
again to select jurors, let me know what you estimate the time you need for your opening is. I will then look at that request and give you a time allotment based on consideration of that request. Each side will be given the same amount of time, and then I will hold you to it. In other words, if you tell me it's going to take an hour, I'm not going to tell you you only have 30 minutes, right? But if you tell me you want 5 hours, I might have some questions about that. But if you tell me you need an hour and I give both sides an hour, at about an hour, you're going to hear me say, counsel, you've got 5 minutes left.
Huh. Wow. I have never, I'm racking my brain. I have never in a criminal trial seen that. So another difference here. So I've never seen that I can think of off the top of my head. In civil trials, it's different. But in criminal trials, I've never seen it where they are given. Okay, now let me back up. There might be a general time frame discussed. Like the only example I can even think of for that is probably like Karen Reed. you know, normally each side they don't even have to be equal. But the thing that is crazy about this to me is the 5-minute thing. This part where he says, I'm going to tell you 5 minutes left. Let me play.
You tell me you need an hour, and I give both sides an hour. In about an hour, you're going to hear me say, counsel, you've got 5 minutes left.
That is, I've never seen in a criminal trial for opening or closing or anything where he says, counsel, you've got 5 minutes left. That is crazy. And I'm sure you guys can imagine why, right? Because that is so disruptive. If someone is, well, hold on, let me think. Sarah Boone, maybe? Is there an exception, guys, for criminal trial? I'm trying to think if there was an exception to that. But that is like, there might, I don't know. In civil trials, you'll see that type of thing. But in criminal trials, you know, it's like, ick. Not a fan.
Use of exhibits or potential exhibits during opening
You know,
statement.
it's like just way to rip the jury out of, like, hopefully the jury's going to be paying attention. Hopefully they're going to be riveted. You know, if you imagine that you're trying to give an opening statement and you're right towards the end of it, right? You're right towards the last bit. And then it's like in the middle of a sentence, like, counsel, you've got 5 minutes left. Like, Jesus, you know what I mean?
Because exhibits are not pre-admitted, even if stipulated to, there has to be an agreement to show the exhibit during the opening. Hopefully you both work together knowing what is coming in and isn't coming in, particularly where there's an agreement that something's coming in, you know, other than spite, there's no good reason to not agree to it because the shoe would be on the other foot, so to speak, down the road.
Other than spite.
And so
Is he assuming there's not going to be spite?
courteous typically pays off with reciprocal courtesy. So work together on that. But technically, if it's not admitted, which nothing is by the time of opening, and there's an objection to using it, you know, I would likely sustain it. For that reason, it's important that you, if you're going to use, for example, like a PowerPoint or something like that, that you share that with the other side at least 72 hours in advance,
Roger that, Miss Mojo.
so that they have a chance to review it and then work out any concerns they have and lodge any objections that can't be worked out with me, you know, 48 hours in advance,
Or
so
twerked
that I
out.
can then look at it and
What
make
about twerked out?
a determination. If I haven't given you a ruling by that time and you're coming into openings without yet having a ruling, I suggest you have more than one version ready to go. One that is anticipates the objection being overruled and one that anticipates it being sustained.
Wow. Interesting. Double the work.
Let me reiterate again, please do not argue during opening statements or in for dire, I should mention as well. Make a request at the beginning of your opening to enter the well and it will be granted. However, an invitation and permission to be in the well is not permission to invade the personal space of jurors. So understand that and stay a few feet back, at least from the bar of the jury well.
A few feet back. How awkward would it be, guys, if you're on a jury or if you're any, like, can you imagine an attorney coming up to, like, right up to your face within a few feet? How weird would that be? Like, I can't imagine anyone would do that, even if there were, like, why would someone do that? Weird. A few
If
feet? Wow.
You are going to use a PowerPoint or some other presentation, you need to choose at the beginning of your presentation whether you want the lights on or off, and they will remain that way throughout your opening rather than turning them on and off again. So I suggest you do a dry.
Now that is freaking insane. Of all the things, what? So if you're going to use a PowerPoint and you want the lights off, you have to do your entire opening in the dark? Why is it that big of this blew my mind. What the actual fuck is this? And what? What? Oh, of all the things, this might be the craziest thing. I just can't
If
even.
you are
I've
going to
never
use,
heard of anything like this in my life. Like, is he going to count how many times they breathe in and out and limit them? I
use
mean,
a PowerPoint or some other presentation, you need to choose at the beginning of your presentation whether you want the lights on or off, and they will remain that way throughout your opening rather than turning them on and off again. So I
what the fuck?
suggest you do a dry run based on what the light looks like at that time to see what that looks like, to see if you want it on or off.
I just don't even know. picturing how awkward would that be, right? It's like the lights are off because there's a PowerPoint. So the lights would have, like, in other words, they're not going to start with a PowerPoint. So if you picture somebody using a PowerPoint, then they go to give their opening statement. It's like the lights are off. The jury can't even see them. And they talk. Then they show the PowerPoint. Then PowerPoint goes away. And then the lights are still off. It's just really funny to picture this. But why? Tell me why. Dude. Heather for the win. Literally imagine this guy in bed. No, thank you. I mean, wow. Just a lot.
Questions about openings. All right.
Questions about openings. Tell me why. He's like, turn the lights off, carry me home.
Next, I have witnesses. Before we do that, let's take a break. We'll take 10 minutes and I'll be back. All right.
All right.
Vanity break, guys. Court is on a break. Okay. Dashing through the snow. Bill Thompson on his sleigh. Okay. We should be coming back here.
Have time left over.
Okay, here we go.
Definitely are going to be getting to. And then if you have time left over, who you would take and in what order.
What? Who you would take?
I do like to use the time efficiently, so I don't generally grant the request if we're normally stopping at 3:30 at 3:10 or so to say, were you into witness? Well, can we just stop here? The answer is generally no. Let's use the 15-20 minutes that we have, because in a 3-month trial that adds up at the end of the day.
Okay, this is another crazy thing. He seems to get more and more sticklery as it goes along. In every trial, actually, speaking of Murdoch, right? Putin was notorious for this. Every single day, it's like, oh, can we just stop here? Now, hold on. What was I going to say?
I don't generally grant the request if we're normally stopping at 3:30 at 3:10 or so to say, when you into witness, well, can we just stop here? The answer is generally no. Let's use the 15-20 minutes that we have, because in a 3-month trial that adds up at the end of the day.
Okay, right. So I know what I was going to say. I mean, he's not wrong about that, right? It does add up. If anyone wants to do the math, be my guest. I mean, it does add up at the end of the day. Oh, speaking of which, we haven't done her in a while. Hang on. Where is it? Here it is. At the end of the day. Yeah. Like if they're finished with the witness, well, let me see what else.
So have enough witnesses ready to go to fill the time. And it's always good to have one or two who you always have at your side. So for example, if the state, a law enforcement officer, who's there, for example, you can call and put on something if worse comes to worse.
Sorry. So it's like if you finish with a witness and it's like 3:10, it's like you've got this one law enforcement witness who you can question them for exactly 20 minutes. And like their job is just to like sit there at your side and just wait for your beck and call, like, okay, come on, end of the day, come on. Let me ask you those same 6 questions. You're the quickie here at the end. I mean, but also here's the other thing. What's interesting is if you imagine, let's just say that they're going to continue the same witness, right? But like, okay, sorry, I'm just thinking of ways around this. So like if you've got a witness, but you don't have another one you want to call, or you don't want to start one that's going to be a weird interruption, then you could have like some filibustering going on. So then what you could have is them going until 3:30, but they're just like, filibustering, right? They could just be talking slower or, asking more elaborate questions. They can't just ask the same question because then it would get objected to for asked and answered. I mean, I guess they could, but anyway, in other words, if they want to fill the time without calling another witness, like there's ways to do that. You know what I mean?
But I want to make sure we use that time efficiently. With, in addition to giving the list of witnesses you're going to call, you need to provide a list of exhibits you intend to introduce with that witness, short of obviously impeachment, so that the other side can look at those. That doesn't include exhibits that you would put in as part of redirect examination. So for example, the defense in the state's case, cross-examines on some other exhibits that you didn't bring up, or there are exhibits that you didn't bring up that would explain what the defense brought up, you don't have to give notice of those exhibits. You don't have to anticipate that. No.
Obviously, what he's saying here, I'll paraphrase. What he's saying is you don't have to predict the future. You don't have to have a squirrely crystal ball. How kind of you, Judge Hitler.
Now, this is not a remedy or a right that I'm likely is going to be resulting in exclusion of evidence. It is something that you're going to have to deal with me if you're not complying with it. And I will figure out something to make.
Oh God, Heather, and everybody, but also Heather because, you know, of this. A bit.
Remedy or a right that I'm likely is going to be resulting in exclusion of evidence. It is something that you're going to have to deal with me if you're not complying with it. And
you guys, what is he referencing here? Yikes.
I will figure out something to make sure that you do, although I don't expect it will be a problem. You should know what exhibits you're going to use, and there's no real secret here about what exhibits go with what witnesses. And I say that because there's always going to be leeway where you have an exhibit that you forgot you need to use, or a witness testifies in a way that you now need to use another exhibit. So, you know, there's leeway there, but giving the other side a general idea of the key exhibits that will be used so that they can review those to prepare, I think is fair. The corollary to my use all the time that we have is don't filibuster.
Oh, fuck.
I will.
I hadn't heard this part. I didn't know he was going to literally say filibuster when I was just talking about it. That's really funny.
Give an example that I have used, that I have
What?
violated my own rule in the past. When I was in your shoes, where I had an associate handling a witness who the next witness was going to be the client, and we didn't want to get to him that day. And he kept turning around thinking he was done. And I kept going like this, meaning fill up the time. Don't do that. Use the time efficiently, but don't filibuster.
So do as I say, not as I do. Noted.
I've learned to come as a judge. You sometimes feel like your client is the jury in some ways, right? You want to make sure that that they are comfortable. You want to make sure they are treated with respect, and make sure that things go as quickly as possible for them. And so I've come to respect that. And so I tend to want to make that happen as much as possible. So, you know, don't waste their time either by having gaps that we can't fill or by filling it with stuff we don't need to use where we could be going to another witness. The lawyer handling a witness, if that is the lawyer handling on direct or the lawyer handling on cross, is the lawyer authorized to speak on the issues related to that witness's testimony at the time it is being offered. And so that is the only lawyer that's authorized to speak about that witness. So if there is a sidebar, only the lawyers handling the witness need approach. If it's specific to that, if it's more general and I need to talk to more of you, I'll let you know that. But I don't want the whole caravan up here for those discussions. Likewise, please do not stretch the shirt sleeve of the lawyer who is handling it by the other lawyer constantly pulling on their sleeve and writing a note and saying, don't say, you know, they'll get it. Just let them do their job.
So this is one of the weirder moments, I feel like.
About that witness.
So basically what he's done, that's normal. That part's normal. The one horse, one rider rule.
If there is a sidebar, only the lawyers handling the witness need approach. If it's specific to that, if it's more general and I need to talk to more of you, I'll let you know that. But I don't want the whole caravan up here for those discussions. Likewise, please do not stretch the shirt sleeve of the lawyer who is handling it by the other lawyer constantly pulling on their sleeve and writing a note and saying, don't say, you know,
What the fuck?
they'll get it. Just let them do their job.
This is where it starts to get even more weird because it's like, okay, we're in May, the trial's in August. It's just the micromanaging. It's like, here's the thing. Some of the stuff needs to be figured out logistically, right? Like the stuff that they've already talked about, you know, for the most part. But the other stuff like this, it's something that you could just address if it happens. I mean, I don't know what the odds are of somebody tugging on somebody's shirt sleeve or what have you, but like, if that happens, you could say, don't do that. But like, this is just, and months ahead of time is weird as well.
I'm assuming that there is, based on our prior motions, a agreement, well, I'm assuming at least one of you would like to exclude witnesses pursuant to 615. Because if that's the case, then they will be excluded, generally speaking.
It was the state's expectation that that's what would occur, and that's why we raised with the court earlier on the specific individuals that we've agreed could stay even if they haven't testified yet.
So 615 is one of those rules where if one side requests it, it's granted as a general matter. And so
Witness exclusionary rule, guys.
I'm assuming that we're going to be using 615 to exclude witnesses except those excluded by or excused from it by the court. Or you can agree not to use 615.
I want to talk about experts, though.
Right.
Experts being allowed to view other expert testimony.
Yeah, that's
Right.
normal. That's par for the course.
Experts are generally
That's par for the course. So let me pull
excused from 615 because part of what they rely upon is the testimony of other experts. Part of what they rebut is the testimony of other experts. So experts generally are excluded. The parties, or in the state's case, a designated party representative, such as a lead investigator, is typically excused from it. I've already talked about the defendant's family in another ruling,
I'm going to
and crime
pull
victims are
up.
excluded from it.
Hang on, guys. Time to learn.
I want some further clarification with our.
Time to learn. All right, let's take a look at this here. Okay. So here's the rule. Excluding witnesses. At a party's request, the court may order witnesses excluded so that they cannot hear other witnesses' testimony, right? Or the court may do so on its own, but this rule does not authorize excluding, one, a party who is a neutral person. Sorry, natural person. Sorry. The party who's in other words, you can't like exclude one of the parties, right? An officer or employee of a party that is not a natural person after being designated as the party's representative by its attorney. A person whose presence a party shows to be essential to presenting the party's claim or defense. An example for that would be in some cases you'll have, well, I would say probably in most, if not all cases, where they have a designated person who's there for the whole trial. Like sometimes, or most oftentimes, it'll be like the lead detective can be present the whole trial. So that would be, when you think about the witness exclusionary rule, it's like, okay, so like immediate family members, right? They are exempt. Experts generally exempt, right? And other people who they've already talked about. But in addition to that list, oh my God, something just fell over. In addition to that list, you can have each party can have like a designee of someone who's present the whole time, as an example there. And then number 4, a crime victim whose exclusion is prohibited. So there's other options there for crime victims. So then there's child witnesses. Yeah, so there you go. So that's the rule there. Yeah. Okay, cool. Now we know. Excellent. Back to the hearing.
Experts.
I think you guys agreed that your investigators would be excluded from it as well.
We did make that agreement.
Yes, exactly. So that would have fallen under, what was it, the 4th example of the rule we just looked at?
Yeah. I'm sorry, I didn't mean to interrupt. I just had that thought. I didn't want to lose it.
So that's okay. I know the court has talked before about the live streaming and being mindful that witnesses not watch the trial when they're outside of the courtroom, just like they couldn't inside of the courtroom. What I want to know is, with experts who are allowed to be in the courtroom, can those that are far away watch the live stream version if
That's
they can't
fair.
make it?
That's fair.
Thompson, you have any objection to that?
No, that seems to make sense, Your Honor. And I understood that the court was going to give them admonishment,
Well,
acknowledgement
also,
to witnesses as they appear.
I mean, also considering there's like the limited seating, right?
Bailiff, could you provide one of these to each side, please? This is an affidavit that each witness will have to sign, and you hand to me as they are going to the stand when you're called by them, specifically declaring that they have not watched the live stream. This is for
Okay.
witnesses who are excluded or otherwise consumed media about the testimony or evidence presented during the trial. That's not I'm not wed to the exact wording. So if you have wording,
Now, I will say, I don't remember if they did this in Chad's trial, but they did do this in Lori's trial in Idaho. Oftentimes, it just depends again on the jurisdiction. Sometimes in trials, you'll have it where when the witness goes to take the stand and they're like going to swear them in, the judge will ask them at that time, have you seen anything about this? Have you been watching anything? Da, da, da. I've seen that happen a lot of times. But other times it's handled maybe outside when they're in the hallway. But I remember specifically with Lori Vallow's trial in Idaho that they did the same thing here with this signing an affidavit thing, because that ended up coming up with David Warwick. Anyway, not that's neither here nor there, but I'm just remembering that this was a thing that they had them do. They had them sign an affidavit. So
suggestions, I certainly will listen to them,
Oh,
but that is the
I
gist, is that they will
absolutely
provide such an
do.
affidavit each as they come to testify. Any concern with that?
Not with the wording, at the moment, a question of clarification
will
though,
say-
if the case should reach a phase 2.
What I will say though is that lay people are typically, I think, pretty terrified by perjury because they probably don't realize that they never pursue that, right? It never happens. But like the penalty of perjury, that whole thing, right, is meant to scare people into not lying. And for most people, I would think probably it works, probably, you know, because they wouldn't realize just how that never happens.
Does this admonition apply to those potential witnesses for phase 2?
So a witness who is only a phase 2 witness
Only a phase 2,
and they attend phase 1. Is that what you're asking?
if they watch or attend any part of phase 1.
Well, the problem with that is that phase 1 is also part of the state's phase 2 evidence, as is the defense's, right?
And I think that would support the need for them to be able to know it if the state's going to rely on things that
Are you talking about experts?
experts and possibly lay people too.
Oh, explain to me why lay people should be excluded from it.
I don't think they should be excluded.
So you think they should not be permitted to watch the trial?
I think I've got some double negatives going on. I think that if we get to a phase 2, I don't
Accurate.
think that those witnesses have to be excluded from paying attention to phase 1. I think the protection for phase 1 is separate than phase 2 because of the rules of evidence that apply to.
Yeah, I agree. I agree.
That apply to
I agree
phase
with that.
2, and because the state's going to rely on what was
Yeah.
in phase 1.
By
So
the
yes,
way, so
experts.
for anyone who didn't know this already, by the way, perfect time to mention, in phase 2, right, in the penalty phase, rules of evidence don't apply. So that is a thing in every state that has a bifurcated trial. So any state that has the death penalty, rules of evidence don't apply. And the same is true actually if you have any type of sentencing phase, right? Like for example, sometimes when you're dealing with like LWOP, they have a separate sentencing like hearing type thing. It's not the same, you know, it's not like an entirely separate thing like you have with the death penalty. But sometimes, you know, depending on the state, they go more in depth with that to where they do like, you know, pre-sentencing, you know, evaluations and whatnot. And they can put on like mitigating, you know, for example, like speaking of Ezra McCandless, right, in Wisconsin, the defense there, they got to put on a number of witnesses to try to, you know, talk about her character and, you know, get a reduced sentence and whatnot. And it was like a whole day, or actually, sorry, it was two whole days on that. But anyway, all that to say that once you've been convicted of a crime and there's a large penalty at stake, the rules of evidence don't apply in anything, you know, once you've been convicted, and just something we should be aware of, because I have strong feelings about that. But regardless, it is what it is.
and some potential.
I can't
lay
change it,
witnesses as well.
unfortunately.
Mr. Thompson or whoever wants to address this?
Our initial inclination is to leave that to the court's discretion. I think the whole purpose is to avoid prospective witnesses altering their testimony in some fashion based on what they've seen going on in court. That's the danger. I don't know why phase 2 witnesses should be treated any differently than phase 1 witnesses.
Well, what I'm going to do is, I'll give you a chance to each submit something within 7 days in writing on that, and I'll look at it so that you can give me any authority that you might come across related to that issue. Give me a chance to think about it further, and for the two of you to perhaps talk to see if you can understand specifically who you might be thinking of, to see if the state has a problem with that. Counsel who calls a witness, unless it's clearly an adverse witness, in which case counsel needs to notify opposing counsel that they have not admonished that witness. But otherwise, counsel is responsible for ensuring witnesses are aware of orders in limine, otherwise clearly off
Right.
a testimony that is off limits. Make sure they understand, the Rule 615 requirements and the fact that they're going to have to sign an affidavit subject to the penalties of perjury that they have not watched this stuff.
There it is. Poetry.
So it's your responsibility to
Oh, yeah,
make sure
that part was weird. Reese's watched to this stuff. Weirdness.
615 requirements and the fact that they're going to have to sign an affidavit subject to the penalties of perjury that they have not watched this stuff. So it's your responsibility to make sure that they're aware, because when they don't comply, I'm going to be asking, why did you make them aware?
When they don't comply, they're going to get beating. He really wants people to comply.
I'm gonna, while we were talking about the jury, I failed to give you the juror affirmation that will have to be signed by the jurors each day. Let me give you a copy of that along the same lines.
Some really loud ass paper shuffling. Can you do that any louder, Judge Hitler?
So that is an affidavit each juror will fill out daily, indicating that they have not violated the court's instruction or otherwise been exposed to testimony or information about the case outside of the trial itself. If I exclude evidence and you need to make an offer of proof, the opportunity to do that generally is when the jury, when we're not working with the jury, such as the morning session or the afternoon session, so that you can make that record as best as possible. That can be done typically by simply making an oral reference to what the witness would have testified or what the evidence would have shown had it been admitted. Okay, let me, I think the rules are pretty clear, but some judges may have more leeway than others about objections. Let me explain to you what my expectations are regarding objections.
Boy.
So objections to questions or exhibits should be stated simply and without argument. It should not be a speaking objection. So for example, an objection, a proper objection might be, for example, objection hearsay.
Rule 801.
Objection foundation requires a little more. As you're probably aware, there's case law that is an insufficient objection.
Yep.
You have to identify what is missing from the foundation as part of your objection. If you think that doing so would put information in front of the jury that you're not certain I'm going to allow, please ask to approach. I tend to be a rather quick on rulings, on objections. I've been known to, testimony objection, then overruled, sustained immediately, without even giving you much of a chance to express.
Are you like bragging about this? I don't understand. Why are you even saying this? I don't understand. This is weird. This is another weird.
Put information in front of the jury that you're not certain I'm going to allow, please ask to approach.
And again, I just have to reiterate, we're months away from trial. This is one of those things where normally what will happen is when trial starts and objections start coming in, it will come out, it will naturally work itself out, right? The judge, with the exception of like Judge Bev, where she's like, don't state your grounds, right? Like normally this is just not addressed ahead of time, months in advance. It's just like so minute. And like, do you expect them to like remember all this from now to August? Like exactly how you want? I don't know. It's wild.
I tend to be a
And this is
rather quick
not whatever.
on rulings, on objections. I've been known to,
There's no reason they need to know this. They'll learn that you're quick when you quickly sustain or overrule. Like, you see what I mean? It's just stupid.
testimony objection, then overruled, sustained
Very weird.
immediately, without even giving you much of a chance to express your concern greater, because
But again, all this just really points to him being like super, like I'm in control, and I don't know. It's kind of weird, right? Not letting them get a word out, I guess.
I can usually anticipate what the potential issue is and whether or not it's an issue. That's it. If you think your ox has been gored and you need to address the issue more, you need to have a record, or in order to
Your ox has been gored.
perhaps convince me that I'm maybe looking at it differently than what you anticipated or than I should, please just ask to approach, and then we can have a discussion here at the bench about that. If you need to make a further record for any reason on an objection or in response to an objection, simply ask to approach, and we will have that discussion. I'm sure by the end of the trial, we'll have to replace the carpet from the trail leading from counsel to the bench, but
Well, that's
fine.
funny. That was,
as I've shown you before, the court reporter will have a device like this that will allow her to hear through her earphones what we're saying. There will be white noise that's played in the courtroom so the jury and others cannot hear what we're talking.
the white noise is normal, by the way, because I know that there are some people that seem to think that was weird. The white noise is completely normal. That is the reason that some people maybe aren't familiar with that is because what happens is when they go to sidebar in trials, what'll happen is the court people, they turn the sound off on their cameras. But if ever they're delayed on doing that or they're late on doing it, like you'll hear the white noise and it's like crazy, right? And it's like will hurt your eardrums. The white noise is standard for every trial. Every single trial they have the white noise. Otherwise, they have to dismiss the jury for every sidebar, and you know that's not going to happen for so many reasons, right? It's ideal to just use the white noise, and if it's going to be an extended sidebar, then they'll dismiss the jury, and then they will usually, discuss whatever the issue is in open court, and then they don't need the white noise. So the white noise is to keep the jury and others, like literally what it says on the screen, right, from hearing what they're talking about.
There will be a physical barrier that blocks most of the view of the jury from what we're talking about at the bench that's rolled out so that they can't see. And we can have fairly fulsome whispered discussions here at the bench about
God, I hate the word fulsome though.
whatever the issue may be. I have found in, doing this for far longer than I care to remember that when I send the jury away to hear argument on an objection, what might take 3 minutes to have the argument on takes 12 to 15 minutes to get the jury back again. And then we lose a lot of time throughout the day that way. And so my preference is as much as possible to have those discussions here at the bench. Now, if it's a very significant issue that requires much more legroom, so to speak, to talk about it, then I will chase them out of the room, but I prefer not to handle the more routine stuff.
That's normal. Again, goes without saying, doesn't need to be said. Does he think they've never done a trial before? It's very odd.
One of the things about, I've had counsel before who confuse the idea of the need to make a record with the need to get my ruling and then offer a rebuttal to it.
Oh boy.
That is not making a record. That is making a rebuttal. And at least until it goes over to State Street, I get the last word and not you. And so I don't generally afford that opportunity. So if after I rule and you tell me you need to make a record, it truly needs to be a record on something that for some reason you were unable to make when you had the opportunity to do so, and not simply to see what my ruling is and then try to pick it apart. I will reiterate what I started with is I don't like surprises. If you anticipate an objection or you anticipate objecting to testimony you certainly know is coming, let's talk it over before the witness hits the stand, before the jury's in the box, so that I have as much time as possible to be prepared so I can give you as best a ruling as I can, and so that you can make as best an argument as you can.
No surprises with Judge Schiffler.
If you anticipate the potential impeachment of a witness by prior testimony, whether that's grand jury testimony, whether that is transcribed witness interviews, whatever it might be, please get that to me before the witness hits the stand, and preferably towards the start of the trial, so that I have that available so I can have read it before the witness testifies, so that when you then ask to either impeach or to refresh recollection or whatever it might be, I will have read that testimony. Don't be mistaken in your belief that I have all that testimony. If it, for example, happened with Judge, I don't necessarily have all those transcripts, so get them to me. Or if I do, they're in one of 100 boxes somewhere back there.
Your Honor, if they've been supplied with exhibits and the purpose was just for that, will that be enough for the court, or should I have an extra transcript at the start of the day if I think I need it on paper?
Why do I have the feeling he's going to say have an extra thing and then some ready?
So let me know as far as advanced as possible, and I will have staff look for that. But otherwise, it's probably safest just to provide me an actual copy of it.
Yep. He's that type of person, that type of dude.
While I'm thinking of it, because I'm in my mind envisioning the materials from grand jury that we have here, the state did file a motion to get back its exhibits for use at trial. I assume there's no objection to that.
No objections.
All right, Mr. Thompson, if you may make arrangements with staff here to get those while you're here, okay?
Yes, sir.
I assume you have replacements you have or will get to me for those.
And actually, we had a procedural question we were asked the clerk. I'll ask Your Honor.
Clerk probably knows better than I do, but I'll go ahead and try.
We can do one of two things. We can either get together a set of photographs or copies of the exhibits and exchange those for the exhibits, or take the exhibits, document them, and then give the clerk what we've documented. We're happy to do it either way.
Well, my only fear is that you take the exhibit and then I don't know what the record is of what it actually looked like. Not to suggest that you would be involved in any chicanery and switching something out, but just trying as best I can to preserve that record.
Understood. So we probably will not do
Chicanery?
that on this trip, but we will make arrangements to have that.
What
done.
about tomfoolery
Thanks, sir.
or horseplay?
Speaking of chicanery, I'm not fond, and you folks know that by now, of making accusations against opposing counsel that are not well-founded and supported by specific actual evidence. I know that you can get along, but I also know that over the course of a trial, particularly a long one, tension rises. And so I remind you of that to be professional. Don't talk to each other directly when we're in court, right? When the session's going, everything goes through the court as you know, the protocol with courts generally is. Refer to each other by professionally, Ms. Taylor, Mr. Thompson, by first name while we're on the record. Again, avoid making accusations that you don't have the tickets for or the receipts for.
Imagine it, like, think about that as applies to Bryan,
And
right?
under no circumstances should you make such accusations in front of the jury. It's a long trial, so as much as I want you to be
Or that's the court feed again.
flexibility about how witnesses are presented. You may have a local witness and a witness who's flown in that needs to get out again at the end of the day. And so it may be that we need to stop one witness's testimony to get the other witness in and then pick the other one up. As long as there's no clear prejudice from that, I'm generally flexible in allowing that so that we can
Again,
accommodate
it's
that.
odd that it's being
And I ask
talked
you
about
to
now.
both be accommodating to each other in that regard.
How much of this is like goes without saying, par for the course? Just very weird.
All right, any questions about witnesses testimony?
Just one and kind of a takeoff of what the court just mentioned. We have at least one, maybe a couple law enforcement witnesses in particular who have testimony relevant to different stages of the case. And it's our intent, with the court's permission, to call them at different times instead of trying to figure out how to call them once and have them talk about what's going on at this stage of the case and then what may be happening next week with the case. Is that acceptable to the court?
Well, let's start with whether it's acceptable with Ms. Taylor.
Oh, there were his hands. Look at his hands, guys.
I don't know that I have a strong objection or really
Hands
any
on the
business in
face.
telling the state how to put on their case. That feels really cumbersome.
What's going on at this stage of the case and then what may be happening next week with the case. Is that acceptable to the court?
You got both hands.
Well, let's start with whether it's acceptable with Ms. Taylor.
Your Honor, I don't know that I have a strong objection or really any business in telling the state how to put on their case. That feels really cumbersome to me. I was hoping for leeway the other way when we would call a witness ourselves, but they're a state's witness. I'd hope to have a little leeway to do all of my examination so they didn't have to come back. I would otherwise defer to the court.
Certainly, if you're somebody's on your witness list, if you want to go beyond the scope of direct as part of effectively your case in chief in advance, I don't have a problem with that. And so if it's going to say bringing another witness back, I don't have a problem with that. I don't have a problem if it doesn't get too cumbersome. If we're having a lot of enforcement talk about
So no
a
caravanning,
broad area of one phase of the
no
investigation at a time, that's
sleeve
probably
tugging,
okay. But, having them come
no
up and
chicanery.
narrate between every other witness is probably too much. Then the question becomes is how do we handle cross-examination? And basically I will defer to the defense on that or the other side on that to the extent that we allow, which is, do you want to cross-examine about the information they just presented now? Or do you want to wait until their last presentation and cross-examine about everything? And so that'll be up to you.
Like, this is so reminiscent of Trevor right now.
That said, then I guess I'd request that the state let us know when they call a law enforcement that's for a limited purpose right now, but is coming back for another purpose.
Yeah, they need to let me know that as well.
Absolutely agree. Agree.
And if you don't let them know that, and either way, it's your responsibility to ensure that they're back at some point available to the defense so that they can cross-examine, even if you decide, oh, I don't need them anymore. You better not send them on an airplane somewhere where they're unattainable.
Right.
Because the remedy may be to strike all of their testimony
Mm-hmm.
as a starting point.
We would anticipate asking court and counsel that this witness may be excused if we're finished with them. And then that would give Ms. Taylor or other counsel an opportunity to let us know whether they still need that person.
Likewise, when you look at each other's witness lists, talk with each other and then write it and get it in writing so we have it as to whether or not, for example, Ms. Taylor will need subpoenas to witnesses you have on your list that they want to also call, or if the other way around, you need subpoenas for their witnesses or whether they will essentially agree to make them available.
Do you think Twiz is thinking about what
Anything
flavor
else with respect to
he's
witnesses
gonna
before we
have?
move to exhibits? Okay. All right. So I did require a meet and confer for you to go over exhibits, and I got those, and I appreciate the start that you have on those. There are a number of exhibits where appears to be, I can't tell. So for example, there's an objection to, for example, relevance or hearsay. Part of what I wanted to know though, to start is, regardless of whether it's ultimately admissible for those reasons, is there an objection to authenticity? In other words, I want to make the trial go as quickly as possible. avoid the need to put on a bunch of witnesses simply to say, this is what this is, and they don't really have any substantive discussion about it. They're just authenticating a document that, if we were to be honest, there's no dispute that it is what it is. And so I may have you go back and look at that and add another column to the list, which is objection to authenticity. Some of the stuff, key actual evidence items, whether that's DNA or whatever it might be. Obviously, the defense is entitled to put the state to its burden with respect to chain of custody and all that. So I don't expect that. But on some of the other stuff, certainly to the extent that we can agree that if there's no good faith basis to contest the authenticity, then let's try to do that for everyone's sake. In that vein, I know the state had to withdraw its request to have certain documents self-authenticated to go back and do more work. Where are we at on that?
Ms. Jennings can speak to that, Your Honor.
Your Honor, I believe that we've submitted all of the certificates of authentication for all the exhibits we plan to introduce that way.
Okay. And you've submitted those to the defense to review? And Ms. Taylor, are you going to respond to those?
Your Honor, we did. We met with the state last week, I believe, or the week before, and we discussed some of those records. There were some issues with them. Ms. Jennings provided me with a thumb drive, and I don't know if those have corrections on them, but I'll continue to let the state know what we think, if we continue with an objection or if we're satisfied that the rule's been met.
Okay. If you could get with each other and then provide me, I didn't study the exhibits that I got a day or two ago, or the spreadsheet that closely, but make sure I'm aware specifically of which exhibits there is no objection to the self-authenticating or otherwise not an objection to authenticity. Doesn't sound like we're going to need a hearing on that, at least for the time being, though.
Not that I'm aware of now, but certainly we'll keep our eye on it. I can alert the court, and if we can squeeze it into June 18th, that's possible. Maybe we
Sure.
can start that at noon.
Okay. And then I would certainly caution, at least because the state goes first for now, I'll say the state that, belts and suspenders are good ideas when it comes to trial. So I would have my
What?
people I need to authenticate things
Belts
under
and
subpoena,
suspenders.
just in case. Especially if they're out-of-state witnesses, because that's not something you can do overnight.
Even make suspenders.
The methods of displaying evidence to the jury, generally there's three ways to do that. One is by putting it on the Elmo and projecting the physical document, whether it's a writing or something else. The other is if it's a writing or something else, using litigation software of some kind to project it through the computer. And the third is passing it through the jury. That last one is the one I want to avoid as much as possible because that just takes too much time. So try to use the other two approaches as much as possible. Now, there are going to be some physical objects that it may be important for the jury to see, and I get that. But in general, photographs, things that are in.
That's the court feed.
So oftentimes, and hopefully that's what you're doing, there's an agreement in advance stipulation to admission of exhibits. I generally don't allow pre-admission because what I find is that I admit all these documents that then are never addressed during the course of the trial. And I don't want a bunch of exhibits to go back to the jury that they have no instructions on, that they've had no question and answer with a witness to explain what the relevance of those things are, so that they can just go back and use to justify whatever position they want to have from them. I think that's dangerous. And so the process, if there's a stipulated to exhibit, would be to, just as you normally would, identify it with the witness, or not even necessarily doing that. You're going to use exhibit 6, witnesses on the stand, and just say, Your Honor, I'd like to go over exhibit 6 with the witness. I understand that the defense has no objection to this. Look at you. That's correct. All right, exhibit 6 is admitted. And then we go from there.
Again, par for the
On
course.
voluminous documents, if possible, try to avoid sending the whole thing back if there's only a small part of it that's relevant. If that's not possible, let's highlight the parts that are relevant and maybe even explain through the witness whether any of the rest of it is relevant, right? So that they know what to look at. In that same vein, if you have a voluminous exhibit and there are, say, 5 or 6 pages from it that are important, what I might suggest is the exhibit be, exhibit 47, and then you have 47A, 47B, 47C as marked exhibits. They go with 47,
all of
but they're
this
separate
is
exhibits so
just
that the jury can keep
par for
those
the course.
in mind, and we can keep track of those. It looks like from what I received, the state's using S-number for its exhibits, and the defense is just using numbers. Is that accurate?
It is.
Hopefully that won't get too confusing for people. Where we can, what I also suggest is that the defense is going to use as part of its case the same exhibit that the state has used and admitted. Let's not admit another copy of the same thing. Let's just use, so let's say the parties don't own the exhibits once they're admitted, the court does. And so there's no proprietary interest there. So if you already have it admitted in the form, just use that exhibit. Okay.
That's how they do it in every freaking trial.
I think my staff explained to you that in terms of submitting exhibits to the court in advance, if you would provide 2 copies of the exhibits in notebooks, so 1 copy in one set of notebooks and 1 copy in the other set of notebooks, and try not to make the notebooks bigger than about 1.5 inches each, at least on the copy you give to me, because it's just too unwieldy to use a 6-inch binder up here, or if I need to take it home and read it overnight, I'd like to do that. So try to keep it to about 1.5 inches per. And then for the actual exhibits that are going to be admitted, provide those first day of trial or whatever to the clerk in each exhibit in a manila folder with the exhibit number marked on the outside of the folder on the tab with the sticker attached inside the exhibit, so that she'll have a box of the proposed exhibits, the originals, and you can ask for exhibit X or whatever and she'll hand it to you to use. These for the document exhibits and photograph exhibits. Physical object exhibits, work with the marshals on getting them in the courthouse. So for example, if it's something that's going to raise alarms at the security line, such as, I don't know, a knife, make sure you've got the aid of security in advance to get through that. The TCA can direct you to the marshal service and who to talk to there. We tend to use for dangerous items like guns and knives, a display box that the item would then be locked in to display to the jury. And so that can go to the jury without fear of an accident happening.
People stabbing each other.
I don't think there are any guns in this case, so I'm not as worried about that in terms of those being pointed at anyone by accident. But in terms of the knife, will probably be in a display case. If you're going to be using illustrative exhibits, give counsel notice of that as reasonably far in advance as possible for them to have a chance to look at those. Items for which chain of custody needs to be maintained until it's admitted, I'm going to leave that to the state to figure out where it's going to be stored and how it's going to be stored. Whether that's with a sister agency or whether you're going to have the sheriff up there bring down a trailer that can be locked up and kept at the sheriff's here property or something like that. However you want to do that, I'll let you worry about that. For physical objects, also provide color photographs so that we can have those in the record. At the end of the trial, we will likely give back physical objects to law enforcement to maintain, depending on what it is, we'll see, and depending on what the outcome of the case is. But it's nice to have those color copies available for the record. Triple check all of your exhibits, particularly documents, audio, and video, to ensure that there's nothing on there that is not supposed to be on there. Give audio and video to counsel far enough in advance they have the opportunity to determine whether they have objection to anything in there, and you have the opportunity to either make redactions in accordance with the objection or to get a ruling from me about those redactions. What I don't want is the jury to be sitting in the back room while you all are making redactions at the last minute during the middle of trial. All right, for closings, kind of the same idea. I'll ask in advance for a time estimate, and then if it's reasonable, agree to it, but then hold you to it. A little bit more liberal, obviously on closing than in opening. If you're going to display things in closing, kind of the same light rule goes, which is lights on or lights off, so you'll have to choose.
Oh my God, that is the
You can move
dumbest.
about the well, but don't get in the juror's personal
Dang.
space. The state, when it gives me a time, I will keep track of that, and then for rebuttal, it'll be whatever you didn't use. So when you're giving me estimates, include your rebuttal in them. If you would like time reminders from the court throughout it, for example, if you're planning to keep 20 minutes for rebuttal, you can ask for a heads up at 30 minutes, something like that, when you have 30 minutes left, so just let me know in advance. All right, questions either about closings or about exhibits?
Wild that he's already
Your Honor, as to the defense
closing
exhibits,
arguments.
it would be helpful if they could be
Months away.
separated or at least delineated between which is for the penalty phase and the guilt phase, as the court will see when it looks at our spreadsheet of our responses to the defense exhibits. Some of them, we could see we wouldn't object to them in penalty phase, but we would in guilt phase, and they aren't clearly delineated at this point. If that's something that we could have addressed sooner than not, that would be very helpful.
Any problem with that, Ms. Taylor?
No problem. We did go over that when we met last week, and I identified which ones were for phase 2 if we get there. I don't have a problem stating so, but we did make them aware.
Okay, well, maybe if you can just put it in writing so that they have it, that'd be helpful. That way we don't have any misunderstanding between the two of you. Thank you. All right, once you get and revise your spreadsheets based upon what we talked about today, I'll start about part of what I'm going to do with the time that we have between now and trial is start going through all those, looking at what your objections are, getting my preliminary thoughts together on that, and then we may have another hearing just to kind of go over some of that if I have stuff that I think I can rule on in advance for you, or if I have questions, et cetera, but I'll let you know. All right, anything else before I move on to jury instructions?
Not from us, Your Honor. Thank you.
As far as objections, Your Honor, the court has issued a number of decisions on motions and limiting motions to dismiss. From the defendant's trial brief, the defendant indicates that he plans to raise those same objections again at trial. And it strikes the state that if that's going to happen, to preserve the record for no other reason, that should be done outside the presence of the jury, as opposed to interrupting testimony and the presentation of evidence on matters that have already been ruled on by the court, if that is acceptable to the court and counsel.
So there's not a need to object again if I've already ruled on the objection. If you're asking me to reconsider, yeah, I think that's something you need to take up outside the presence of the jury, if that makes sense.
That does make sense. And on situations that may arise where we might want the court to reconsider, we'll definitely take that up outside the presence of the jury. I do want to make sure that things such as the model house that was a subject of a lot of objection, that there's a noted ongoing objection to it. I don't mind anticipating that and bringing that up before trial starts and outside the presence of the jury.
And to be fair, I only have what was proffered, right? And so I had a general proffer that the testimony will be that it, as I understand it, that it is consistent with the general layout, but not to scale, and that it would be helpful for the testimony.
Huge element of control,
I don't have a problem with
without doubt.
an objection based upon what that proffer is actually at the time. And so I think that's fine. I don't think that there's a need for an ongoing objection once that's done, but that helps.
Yes, sir. Thank you.
Jury instructions, I provided to you, I think yesterday, maybe pre-proof instructions. Did you get those?
I did not receive those.
Have we not sent those out? All right, I'll send those out probably today or Monday. They're not particularly, I think, controversial. They're pretty stock. On the pre-proof, in a capital case, there's a instruction. Normally what we instruct the jury is don't concern yourself with punishment, the subject of punishment. In a capital case, we are supposed to instruct them under 700B of the capital
These attorneys all know this.
instructions in the pre-proof phase, that it is a capital case, which obviously they're going to know through jury selection. So there's that instruction in there. And what I've done is we're also supposed to instruct them with 700C, which is this is a capital case and you'll have to decide if you find the defendant guilty, what penalty to impose. But then 700C says, instruct them in a separate instruction, don't concern yourself with the subject of penalty or punishment in the guilt phase. I've combined those two things together. So take a look at that. I think it reads better than trying to do two separate, potentially contradictory instructions. I think it does it in a way that makes it more understandable. Other than that, they're very, very stock instructions. If there are other instructions that the parties want to be included in the pre-proof, for example, any stipulations that they want me to advise the jury of, let me know.
It's weird because earlier he said the thing about like, if anyone's watching this, it's like, what?
By submitting a request and copying
funny,
my law
right?
clerk on that as well. I think you'll probably get before too long a set of post-proof instructions that are very loose in the sense that obviously I can't anticipate everything. It is based on what I sort of understand now. But it's helpful to have a discussion about that as early as possible so that we're all singing from the same hymnal in terms of what the likely instructions are going
Now
to
that one he's trying to steal from Dick Harpootlian, and get it right, Hippler. It's singing from the same sheet of music. He had to go biblical on it though. Same hymnal.
And, for better or worse, as you know, the Supreme Court in last year, 2024, revised all their capital instructions. And so in light of that, I will be as much as possible sticking with what they have provided, given that it's clear they've obviously given it recent thought. And so I think that best insulates the case from perceived error by the court is by using instructions they've recently given us. My plan would be, if there is a guilty verdict on the any of the counts of murder, would begin the penalty phase as soon thereafter as we can. certainly probably the next day, unless it's, Friday morning when we get that, then we may not start till Monday or something. But
Meg. I did go over that.
given that the jury will certainly be sequestered during that process, the plan would be to go forward. I also will use as much time as I've told you throughout the day to get that accomplished as we can.
And we watched an interview.
If
with
that
Dick
happens and we are
Julian
in a penalty phase,
from like a week ago or something.
and there is a finding of aggravating circumstances, where then the court's discretion about which penalty to impose is pretty limited in terms of my discretion. In fact, i.e. none. It's either life without parole or death, right? In that case, I just want to get, before we get to that
I find it
defensive,
highly disturbing how he laughs when he says death.
limited in terms of my discretion. In fact, i.e. none. It's either life without parole or death, right? In that case, I just want to get, before we get to that defense's position on sentencing for the burglary charge, if they have concerns about sentencing at that time as well, given that it's probably not even a tail wag on the dog, let alone wagging the dog. So
It was that same live stream.
I'm not going to make you tell me that now, but I will ask you before the jury goes out what you want to do.
Yeah, before we watched the interview with Dick Harpootlian the other day, yesterday, we went over all the Becky Hill stuff before that. In the same live stream, though. In the same live stream.
I'm going to hand you another piece of paper that I would like to get back from the defense sometime in late June or early July, which is a declaration of last best offer. In other words, identifying whether the defendant received an offer and whether he has accepted, rejected, et cetera, just so that
I found that to be interesting. Last best offer.
is a declaration of last best offer. In other words, identifying whether the defendant received an offer and whether he has accepted, rejected, et cetera,
Plea deal.
just so that for purposes of post-conviction, we documented that. Okay. Let the court recorder know whether you're going to want routinely daily transcripts or not.
Probably the answer.
You don't have to tell her now, but
Daily versus real time.
so there's two options. You can have none, both, or all, or either. One is I think we can set
More
up
than two.
real time where you get real time at your table for whatever the charge is from the court reporter for that. Also, there's the potential to get transcripts each day. I don't think those things are mutually exclusive. In other words, you could order both.
For separate fees if I want both.
Correct.
Yeah, make that decision.
Yes, not now. You may make that as we get close.
I'm laughing because he's like, we don't have to make that decision now. But like detailing the lights being on or off during closing arguments and many other things that are so minute and so far away. And it's like, anyway, it's just funny that he's like, no, we don't have to worry about that now. Or don't be crazy. Let's worry about that later on. Like, what the fuck?
Just contact the TCA and she will talk with the court reporters that will be assigned to this to make sure you understand what their structure is, or fee structure.
Thank you.
And we obviously need to know particularly about the real time in advance so that we have the technology set up for it. And it may require you to bring some of your own technology in the form of a tablet or a laptop on which it's displayed, right? Because we don't supply the hardware, just the software and the actual reporting. Okay. My plan today, as we sit, is to get through the jury selection. I see where we're at with the intent that we not sequester to start. As I explained this morning, the more people talk to the media and the more things that are in the media that are not
Here's the
admissible,
part.
whether true or not, the more difficult it makes things. And so I'm going to have to figure that out as we get close. For now, intent is not to do that, but we will have plans in place to revert to that if we have to at any point during the trial. Do either of you want to make a record about sequestration at this point?
I would say the only record right now is that we understand what the court is saying during jury selection. If we still don't know if that could come up, the potential jurors should just be aware that it could come up prior.
It'll be part of the question that the questionnaire, as well as part of the hardship determination is there some reason they would be unable? I get that they wouldn't like to be, but would they be unable? Do they have a sick family member they care for or whatever, where they have to be home, right? So we'll talk to them about that. Anything from you, Counsel Johnson, about that?
Not at this point. I understand the court might entertain some things in a closed environment later today, and we do have some sensitive issues to raise at that point.
Okay. That's my list of things. Did I miss anything, Giovanna, that you think of? That's my list of stuff. And I know this has been a very sort of nuts and bolts kind of lawyer
Nuts and
discussion today, but that's generally the nature of pretrials when there aren't contested motions to discuss. And so that's my list. I'm happy to answer any questions about.
Although much of this that he said in this hearing was as if they had never been a lawyer before. But anyway,
my preferences or how I handle things that I haven't talked about or address anything else that you want to talk about. I know we do need to go to a closed session at some point to talk about what will be asked of the jury specifically. I need to avoid that getting out to potential jurors. So we'll do that in a closed session. But anything else in the public session we need to talk about?
I believe so, Your Honor. Thank you.
Thank you.
Okay. Let me just look at my notes real quick before I dismiss the public, and we probably take a lunch break and then come back and take that up. I do have a copy. I told you there's a new administrative order. I'll give you a copy of that just so you don't have to go dig for that. What's that? You've already given it to him? All right, perfect. Thank you.
oh, that was the part. Hold on. Let me back that up. We were trying to listen for this part here.
I do have a copy. I told you there's a new administrative order. I'll give you a copy of that just so you don't have to go dig for that. What's that? You've already given it to him? All right, perfect. Thank you.
So when somebody in the chat was asking about this, like when did the defense get their copy of the order? But that's what I think they're referencing there. So
I do have a copy. I told you there's a new administrative order. I'll give you a copy of that just so you don't have to go dig for that. What's that?
so I don't know who he's talking to when he says give you.
I told you there's a new administrative order. I'll give you a copy of that just so you don't have to go dig for that. What's that?
I mean, I
You've
assume
already-
that's what he's talking about.
I give it to him. All right, perfect. Thank you.
The order that we covered at the beginning of the live stream.
Is there that we could have, Your Honor? That-
Sure.
Okay. It's already at hand. Thank you.
Actually, I have copies of the preliminary instructions for you.
Oh, thank you, sir.
In the closed session this morning, I indicated to you I am going to be entering an order
Oh, never mind. I jumped the gun.
requiring retention of records by,
Okay, I jumped the gun. This is it. So that administrative order was something else. This is the one. Okay.
in the closed session this morning, I indicated to you I am going to be entering an order requiring retention of records by
Okay.
the state, and I'm going to write another one extending that to the defense
There we
as it
go.
relates to violations of the non-dissemination order.
Okay.
I'm going to give you a copy of what that order is.
Part that's whoever, I forget who it was in the scroll chat was asking. So let's hear that again. That's what we were looking for.
By the state, and I'm going to write another one extending that to the defense
So yeah, again, it was really dealing with the state and he's going to write another one extending the defense. Uh-huh.
as it relates to violations of the non-dissemination order. I'm going to give you a copy of what that order is going to look like. I
That's
will
funny,
execute likely over
Meg.
the lunch hour. It does require some action on your part, counsel. And as I indicated, I would be open to a request for a appointment of a special prosecutor
Uh-huh.
and that special prosecutor to ask for magistrate inquiry so they have the power of subpoena and the power to question witnesses under oath, as well as the power to grant immunity. So I will be looking for that from you. And that one just deals with the state. I will get you one that deals with your side to preserve records, all right? All right.
Okay.
Anything else?
So he, at this point, he hasn't actually written the one for the defense. That's what it is.
I will get you one that deals with your side to preserve records,
Okay.
all right?
So in other words, he has to, I mean, it just makes sense, right? Like in other words, even if it was, he knows that the leak came from the state side, you know, yeah, give one to the defense too, just to make sure that everyone's on the same page. Yeah.
Anything else? All right, thank you.
As well.
Why don't we come back in about an hour, all right?
That's it. So this was not planned watching this hearing, but we've done it. We can still watch it again for anybody who wants to. I guess if you're listening to this, you wouldn't be one of the people who missed it potentially. But anyway, but there we go. So we did all the things. We read all the most recent filings, of which there were 3, and we took a look at the car, the suspect 1. We took a look at the cell stuff. We took a look at the different versions of the amended non-dissemination order. Took a look at a number of things, and as well as the hearing. Look at that face on Judge Hippler here. What is he doing with his tongue? Anyway, And there's our friend Twiz. Good job, Twiz. Good job, Twiz. So that's it, guys. And actually, Karen Reed will be starting here soon. I'm going to keep an eye out because I wonder if they're going to come in this morning and address this whole situation with the Commonwealth changing the time of the accident. If so, I will probably go live with that. Otherwise, we'll cover trial tonight, unless something crazy happens. Anyway, I'll just keep an eye out for that. But yeah, that's it for this one, guys. Meg says she's surprised Hippler is not more pissed. Yeah, he was really exerting his pissed offness via control freakiness, I suppose you could say this time. I feel like, yeah, Meg is off to mod as per usual. I'm sure I'll see you in the chat as well, Meg. Unless I'm actually also streaming, but I will pop in there. But yeah, that'll be it for this one, guys. So thanks everybody for being here. Love y'all. Welcome to all the new Squirrel friends, and you're very welcome. Very, very welcome. Thanks to you guys for being amazing. I love y'all. Y'all are the best. So we will be back here soon enough with Karen Reed. And but for now, squirrel out.